First matter, kindly pass over to matter for the day.
Single bench matter?
Yes, Lordship.
Do you see that there's a division bench sitting now?
No, Lordship. Yeah.
Huh?
Yeah. In single bench.
Now it's the division bench.
Sorry.
Morning.
May it please your lordship. So the other day, I was taking your lordship to various statements we have made in our affidavit. In paragraph 31, I went up to 12 of paragraph 31, up to page 266. The last thing I placed the other day was the violence profile in BTAD after signing of the MOS Annexure 10. Page 266, internal page 27.
Of your counter affidavit.
Of my counter affidavit.
Uh,
The regular page is 266.
yes.
So I placed up to Annexure 10, that is the violence profile.
Yes.
There was almost zero, in fact, zero violence after the accord was signed. Prior to that, it was 4,000 plus violence incidents. May I continue with that? Further, in clause 3.2 of the second Bodo Accord, there was a scope of exclusion of villages if they do not conform to the norms of more than 50% tribal population or contiguity. The third Bodo Accord has more clarity as per clause 3.1 Roman 1 and clause 3.1 Roman 2, as they indicate both inclusion as well as exclusion of villages subject to fulfillment of the stated condition. Moreover, any such recommendation with regard to inclusion and exclusion will only be done after completion of the due legal and constitutional process. So earlier, the second Bodo Accord only said that how to include a place on the basis of that 50% norms as well as contiguity. Now in this, there is it is further expanded by saying that if the clauses, if the criteria that is 50% tribal population as well as contiguity, these two factors will be considered for not only inclusion, for exclusion also. If the criteria has to be rationally applied, and all the parties have agreed. If a particular area which is included in BTC area, lordship, if that percentage of tribal people is 20%, for example, out of 100, in that case, lordship, that will go out, certainly. Because the other 80% of the population, they do not, and they should not get the benefit of 6th Schedule benefits. Why should they? So that is a rational application of the principles. So, and that will also be done as per the legal and due constitutional process. It is not that arbitrarily overnight it will be done. And for that purpose, under paragraph 14 of the 6th Schedule, the commission was constituted. Going to next page. As regards statements in paragraph 13R of the PL, the deponent denies the averment made by the petitioner in clause 3.1 Roman 3 of the third Bodo Accord speak about increasing of seats after alteration of area, justification of which has already been made in the earlier paragraph 31. The deponent further submits that this clause is similar to clause 4.2 of the second Bodo Accord, which highlights about 6 in the proposed council. So regarding seats for various elections and various blocks, lordship, that will be considered as per the population pattern. That will be a delimitation exercise. Regarding the names, paragraph 33, the 3FF I have placed already. The name can be changed by the governor to a public notification. Paragraph 34, we have stated, as per clause 13G of the 6th Schedule, the governor may by public notification determine the boundary of any autonomous district. Similarly, clause 13D and 13E talks about increasing and diminishing the area of any autonomous district. Hence, the objection of the petitioner in this regard to clause 4.4 of the accord is unreasonable. Now, paragraph 35, because they have objection regarding bringing the higher rank officer also into the administrative setup of BTC. The deponent denies the averment made by the petitioner and humbly begs to submit that clause 4.4, which reads that executive function of BTC shall be exercised to the chief executive officer, not below the rank of principal secretary of the government. They have objection regarding this. Senior most officers of various departments of BTC shall not be below the rank of additional secretary to government of Assam. Talks about the rank of principal secretary and other officers of BTC. BTC at present consists of 5 districts and generally an officer of the rank of commissioner and secretary is a lower rank officer. Secretary, joint secretary is made the deputy commissioner of the district. Since the administrative setup of BTC is at apex level, it is natural that a high ranking officer for the rank of chief executive officer is appointed. Hence, the objection of petitioner is not justified. So, what the administrative setup now says, it has to have a pyramidal structure. At the top, the principal secretary, then the other junior officers below him at the district level. So when the BTC is a composite unit comprising of all the districts, the deputy commissioner, if the deputy commissioner and the BTC chief means chief executive officer here, CEO, not chief. BTC, the chief executive officer, if they are of the same rank, there is always a tussle. If all the officers of the same rank and the CEO also is of the same rank, then the deputy commissioner may not like to obey to the directions of the chief executive officer. So therefore, under this agreement, it has been decided that a principal secretary, because the principal secretary officer of the state will not become a deputy commissioner in a district. The deputy commissioner level officers comes from the rank of commissioner and secretary, joint secretary, the lower hierarchy. So this is a part of administrative reform so that the officers are in sync with the overall system. Then they have objection about clause 7.2, 36 paragraph. The deponent denies the averment made by the petitioner and humbly begs to submit that clause 7.2 of the third Bodo Accord, which reads as government of Assam will effectively measures to protect khas land, grazing land, water bodies from illegal encroachment. Aims to protect khas land, grazing land, and water bodies from illegal encroachment as it is the responsibility of the administrative setup at all levels to protect such areas from illegal encroachers. And since this is a general clause, the petitioner should not have objection to it. In fact, the petitioners have distorted the facts about clause 7, which provides for protection of government land from illegal encroachment and even falsely termed it as draconian. So according to the petitioner, it is a draconian clause in the, that is why we are saying that it is not draconian, it is a general clause and which will be beneficial for overall public interest as well as the state of the land of the state. In actual, it has been a major demand of the indigenous communities themselves to protect their land and territory from illegal encroachment. The contention of the petitioner are far from ground reality. What is the problem in Assam, Lordship? We have a major problem of infiltration of illegal migrants from the neighboring country, that is Bangladesh. Nobody can deny it. And most of the areas in BTC area as well as other parts of the state, the illegal immigrants have come and occupied, be it the Char area in the river Brahmaputra or the forest areas or the other areas within the state which are lying empty. The population of tribal people in our BTC area as well as other areas are very sparse. If Lordships look at the density of Kokrajhar or the density of the BTC area comprising of the 4 or 5 districts, plus the Dima Hasao, plus the Karbi Anglong, the population is very thin in comparison to the other plain areas comprising of the other part of the state. The population density of Kamrup Dibrugarh, Golaghat, Morigaon, Nagaon. These are all in the plain areas. Land is mostly occupied in all these plain areas, but in the hilly areas of the two districts of Karbi Anglong and Dima Hasao, as well as in tribal areas in Pokrajhar, where a lot of forest areas are there, reserve forests are there, large scale encroachment has been done by the illegal immigrants. Lot of datas are there, Lordship. It is not that all of a sudden this has been taken into, that responsibility has taken by the state. In fact, it is the duty bound. If a government protected land is occupied by some illegal immigrants or by any unauthorized person, whether they are the citizens of the country or non-citizens of the country, it is the duty of the government to remove the encroachment. So that clause is also causing grievance to the other part side. This is most unreasonable in my humble submission. So the ground reality is that we have to protect our forest areas, our water bodies areas, as well as the vacant land, vacant government land, for development of that area and to preserve the serenity of the area. If the forests are, we have so many PLs, Lordship knows, the forest area in Hojai and all, in Kaziranga, large scale illegal immigrants were occupying. Now, during the course of last 7-8 years, everything has been removed. And those who are landless, they are giving protection in other areas. They are giving resettlement. Now, recently, the other day I was facing a case in the National Green Tribunal, Lordship. There is large scale encroachment in the inner line forest in Kachar, Hailakandi, as well as Karimganj district, which has a border with Mizoram. We had huge dispute and there was cross-border firing in 2021, killing about 6 police persons from the Assam police, as well as 1 SP of Kachar, who was seriously injured. Till now, he has not recovered. There we have stationed a commando battalion in an area. That area was occupied by illegal immigrants from the Bangladesh area, as well as from the state of Assam also. And they asked for land rights in a PIL in this honorable court. And this honorable court rejected their plea. Immediately, we removed them. And in that cleared up area, we are stationing the commando battalion. So this is the ground reality of the state of Assam, whether it is in 6 schedule areas or in other non-6 schedule areas. So my humble submission is that this challenge to clause 7 is absolutely misconceived. Absolutely misconceived, and with a mollified intention, maybe they have prayed. I do not know whose brief they are taking. If this clause is creating any problem, it is creating any problem to only the encroachers and illegal immigrants. No indigenous people of BTC will object to this clause, whether he belongs to BTC area as well as for other parts of the state. Nobody can have any objection to this. Any rational, prudent person will support this clause. Then paragraph 39. We have very clearly stated the deponent denies the averment made by the petitioner and begs to submitted notification dated 4/6/2021 only entrusted the deputy commissioners with the task of monitoring and supervising of certain schemes under the 16 transferred subject. It does not interfere with the basic terms and conditions of OM dated 16/10/2021, by which the implementation of the schemes of the entrusted subject continues to vest in the council within the framework of the amendment of the 6th schedule to the 6th schedule of the Constitution. Hence, there is no erosion of power of the council and no violation of the provisions of the Constitution of India. As regards charges of the petitioners against powers and functions of the deputy commissioner in BTR, they have failed to appreciate that dual and competitive administrative hierarchy, that is BTC vis-a-vis the state government, is not desirable, and that the BTC would maintain its autonomy as enjoyed by the other autonomous council functioning in the state 6th schedule. So my humble submission here is that I am also representing the BTC council. we have no objection. And we are the elected representative. And who signed at that point of time, witnessed, he was the chief of the BTC Council. So they also, the main leader of BPF, he was a part of the signing exercise. So he did not object. So now the second rung and third rung leaders are challenging this. So there may be internal issues I do not want to comment, or I do not have knowledge also. But the thing is that whoever is at the helm of affairs in BTC, they have supported whatever administrative reforms or changes that are projected in the third Bodo Accord. Paragraph 40. Deputy commissioners of the districts of BTC cannot override any of the decisions of the council. Whatever council decides, they are the implementing officers. Just like in this court, whatever the cabinet decides on the policy matters, various bureaucrats of the executive lordship, their role is to implement the policy decisions of the state of Assam. The bureaucrats are not responsible for making any policy decision. The decision-making authority under the structure of our constitution is very clear, well demarcated, well alienated areas. There is no conflict. Whatever the BTC, that is the political head of the state, of the BTC area, they decide. There's an assembly. That has to be implemented by the deputy. How can deputy commissioner, it is just imaginary, how can deputy commissioner override the decision of the BTC council? It will fall down, the whole system will crumble. So it has been mentioned that deputy commissioner will exercise powers as may be given by the BTC, and for which the principal secretary BTC will submit a report to the government so that the officers are answerable to the BTC to that extent. So there is a structure. The principal secretary, that is the CEO, the BTC will percolate the policy decision to the CEO, and CEO, chief executive officer, being manned by a principal secretary of the state, will give the direction to the concerned deputy commissioner, and deputy commissioners have to report back to the principal CEO. The services of the deputy commissioners are partially placed at the disposal of BTC for them to utilize their services as required. So the deputy commissioners are from the state cadres or from the IS cadres. The rest I have already placed, Lordship. It is basically regarding the Department of Hill Area, as well as the welfare of plain tribes and other backward classes. A separate department has been created. Paragraph 51. The deponent humbly begs to state that the MOS, popularly known as Third Bodo Accord, was signed on 27 January in presence of the Honorable Home Minister, Sri Amit Shah, the President and General Secretary of APSU, representatives of the 4 NDFP factions, President of UBPO, the Government of Assam, and the Ministry of Home Affairs, Government of India, were the signatories to the MOS. While the President and Secretary of APSU, the Chairman of BPSC, and the Government of Assam were the signatories of the first Bodo Accord, which was signed on 20th February 1993. The first Bodo Accord was followed by another MOS signed by the Government of India, Government of Assam, and the Chairman, Bodo Liberation Tiger, on 10th of February. So that's chronological way. We have who are the signatories at various points of time. And finally, we made our submission. It appears that large number of socially responsible persons belonging to Bodo community have entered into the third MOS, that is the third Bodo Accord, in order to achieve an overall development such as to fulfill the political ambitions, the administrative and economic, social, cultural purposes, and to keep intact the identity-related aspirations of the Bodo community. Before signing the MOS, several rounds of talks were done with representatives of the Bodo community. Further, there is an elaborate provisions kept in the MOS for redressal of any issue that may arise. After the MOS, that is third Bodo Accord, violence, murder, kidnapping, extortion, etc. has drastically come down. In fact, it has come down to 0. The contention of the petitioners that the MOS would dilute the power of BTC are also unfounded. In fact, implementation of this MOS would result in further empowerment of BTC. In view of above, prayers made by the petitioner undergoes misconception, misunderstanding, and inability to conceive the letter and spirit of the third Bodo Accord. Hence, PL is liable to be dismissed and set aside. In fact, it should be dismissed not only simply, Lordship, but with exemplary cost also. In support of my case, Lordship, I have already made my arguments while facing this. So I would like to place 2-3 judgments. My first judgment and my first principle of attack is, Lordship, that it is a politically motivated case. All their grounds the other day I have expressed and I have shown also. They have used that political dilution, etc. in their grounds. I do not want to repeat all these things once more. Thank you. That politically motivated case are not maintainable in the garb of PIL. So 2004-3 SCC page 349. 349. Ashok Kumar Pandey versus State of West Bengal. Paragraph 4.
Hold on. Just a minute.
No,
Books are yet to come.
no. In the meantime, let me place the 6th schedule.
Yes.
Yes.
Thank you.
First, we will go to the Constitution, Article 244(2).
244.
244(2). The scheduled and tribal areas, part 10. Article 244 says, administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of the scheduled areas and tribal in any state other than states of Assam, Meghalaya, Tripura, and Mizoram. There are subsequent amendments. 2 says, the provisions of the 6th schedule shall apply to the administration of the tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram. So in 2003, after the amendment which they have placed, Lordship, in their PIL, the 6th schedule area of the BTC was constituted by comprising of few districts of Assam in the northern side of Brahmaputra, Lordship, and thereafter the third 6th schedule area of the Assam was born. First was in 1955, the Dima Hasao, then the Karbi Anglong, and in 2003, the third 6th schedule area. It has to be governed by the 6th schedule provisions, which Lordship will find in the Constitution. Provisions as to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Lordship will now kindly come to the 6th schedule.
Yes.
Autonomous districts and autonomous regions. Subject to the provisions of this paragraph, the tribal areas in each item of the table appended to paragraph 20 of this schedule shall be an autonomous district. If there are different schedule types in an autonomous district, the governor may, by public notification, divide the area and or areas inhabited by them into autonomous regions. 3, the governor may, by public notification. So in Assam, we have the 3 schedule areas of 3 different tribal people inhabiting there. The governor may, by public notification, include any area in or any of the parts of the said table, exclude any area from any of the parts of the said table, create a new autonomous district, increase the area of any autonomous district, diminish the area of any autonomous district, unite two or more autonomous districts or part thereof so as to form one autonomous district. So all these powers regarding the area has been generated by paragraph 1, subpara 3 of the sixth schedule. And next page, double F. F is unite two or more, and FF says alter the name of any autonomous district. So BTR, BTAD, BTC, there are changes of names. So everything has been done. There is a power given to the governor by public notification. Then G, define the boundaries of any autonomous districts. Provided that no order shall be made by the governor under clause C, D, E, and F of this subparagraph, except after consideration of the report of a commission. Lordship will kindly mark this. Report of a commission appointed under subpara 1 of paragraph 14 of this schedule. So he can do all these things as given in C, D, E, and F. C is create a new autonomous district. D is increase the area of any autonomous district. E is diminish the area of any autonomous district. For the first part, A and B, it is that commission role is not there. So that the parliament takes call. Here, the governor can do it by appointing a commission and report of the commission. Provided further that any order made by the governor under this subpara may contain such incidental and consequential provisions, including amendment of any paragraph 20 and of any item in any parts of the said table to appear to the governor to be necessary for giving effect to the provisions of this order. That is not very relevant at this stage because we are not harping upon paragraph 20. So this paragraph is very important. Now the other paragraph says constitution of district council and regional council. We are not concerned. Powers of the district council, paragraph 3, etc. 4, administration of justice in autonomous district and autonomous council. That is also not the subject matter here. 5, conferment of power under code of CPC, CRPC, etc., which is also not subject matter. Paragraph 6 is not subject matter. District and regional fund, paragraph 7. Paragraph 8, power to assess and collect land revenue and to impose taxes. 9, licenses or lease for purpose of prospecting for or extraction of minerals, etc. 10, powers of the district council to make regulations for the control of money lending and trading by non-tribals. 11, publication of laws, rules, regulations made under the schedule. 12, application of the acts of parliament and the acts of the state. There are several parts of paragraph 12. Then 13, estimated receipts and expenditure pertaining to autonomous district to be shown separately in annual financial statement, the financial management. May I read it? The estimated receipts and expenditure pertaining to an autonomous district which are to be credited to or is to be made from consolidated fund of the state. That is why the department is very important. The state will have to give substantial fund. One part comes from the central, the other parts come from the state. For managing and monitoring that fund, Lordship, a separate department has been now created. Earlier, the general department was there. So it is necessary. It is not to override the power of BTC. It is for proper management because there has to, the state where the fund will not come. From here, where the BTC will take the fund. It has to be channelized. The administrative department has to be there. Suppose for education fund, the finance department after the budget has the fund. It has to be channelized to the administrative department. For example, education. For example, animal husbandry. So there is a veterinary and animal husbandry department, fishery department. Various departments are there. Those departments are channelizing. Here, this particular department, Bodoland Territorial Area Department, BTC department has been. They will not control the fund. The fund will be utilized by the BTC as per their policy decision through the deputy commissioners under the chief executive officer of BTC, and everything has to be accountable in the BTC council. They have a budget, they have a debate, they have all the activities. what is BTC? What is a sixth schedule area? It is a state within the state. So whatever we are doing at the state level, same thing, autonomy has been given to the sixth schedule areas, or sixth schedule regions, to be more appropriate. So there is a, what is the role of CEM, Chief Executive Member? His role is identical to the Chief Minister of the state in BTC. What are the EMs, Executive Members? Executive members are the equivalent to ministers of the state. So that is the scheme, that is the structure. So the BTC area is a state within the state of Assam, just like NC Hills, Dima Hasao nowadays, and Karbi Anglong Autonomous Council. They are a state within the state. Full autonomy has been given. 2 subjects are not transferred. One is law and order, is not transferred till then. That the state has the control. Just like certain things the central government controls, like the these our currencies, etc., passport. These are not the area of the state. Citizenship, not the area of state. So, may I continue? The estimated receipt and expenditure pertaining to an autonomous district, which are to be credited to or is to be made from the consolidated fund of the state, shall be first placed before the district council for discussion, and after such discussion be shown separately in the annual financial statement of the state to be laid before the legislature of the state under Article 202. So they will discuss, they will find out what is the expenditure. It will pass to the state budget. Because this will be part of the consolidated fund of the state. So everybody is accountable. But in what area the amount has to be spent? What are the priorities of development in the district, in the council? That is the domain of the BTC council. For that, the state will not say anything. Unless the accord says that state will fund for the cultural heritage center, or I have already placed those things, Lordship, or a central university by the central government's fund. So the regular everything is governed by, is controlled and monitored by the BTC, and they have to receive the fund from the state consolidated fund. Now 14, the area, territory of BTC. Para 14 says appointment of commission to inquire into and report on the administration of autonomous districts and autonomous regions. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous districts and autonomous regions in the state, including matters specified in clause C, D, E, F of para 3 of paragraph 1. I have just said that area, increase, decrease, etc. C says create a new autonomous district. D says increase the area of any autonomous district. E says diminish the area of any autonomous district. So this commission, including matters specified in clause C, D, E, and F of the subpara 3 of paragraph 1 of this schedule, or may appoint a commission to inquire into and report from time to time on the administration of autonomous districts and autonomous regions in the state generally, and in particular to provisions of the educational and medical facilities, need for any special legislation, administration of laws, rules, etc., and define the procedures to be followed by commission. Apart from various activities, this commission can look into one major area is, which is already stated in the first 14 subpara 1 says the role to be played for the purpose of paragraph 1 subpara 3 C, D, E, and F. And what are the other areas this commission can work into? Look into the educational, medical facilities, communications, etc. Special legislation required, whether it is there or not. Administration of law, rules, regulations, etc. and define. And also into various other financial anomalies also. That has happened in Meghalaya. Commission was, when there was large-scale rampant corruption in Garo Hill Autonomous Council. My Lord Justice Goswami will definitely know all those old cases. So this commission has to be appointed by the governor. The report of such commissions, 2, the report of every such commission with the recommendation of the governor with respect thereto shall be laid before the legislature of the state by the minister concerned together with a explanatory memorandum regarding the actions proposed to be taken thereon by the government of the state. So there is a check and balances within the constitutional provision. So one minister has to be assigned the role of the minister of BTC and other hill districts or other 6 scheduled areas of the state. Hill Area Development Department is one department. So here is a minister of hill area development, and his role is that when the commission report comes with a recommendation of the governor, because the BTC, CEM or EM have no role in the state assembly. So whatever the governor says, it has to be placed and debated in the state assembly. And these are constitutional provisions. It is not made by this accord or by the state of Assam or by the BTC or by the central government alone. These are parliamentary structures. So through the minister, which will be laid before the legislature of the state, that means in this court it will be laid by the minister concerned, that means the HAD minister, together with explanatory memorandum regarding the action proposed to be taken thereon by the state of Assam. In allocating the business of the government of the state amongst his ministers, the governor may place one of his ministers specially in charge of the welfare of autonomous districts and autonomous regions of the state. So everything is taken care of. Nobody can, all the roles are guided by the constitution. Then annulment and suspension 15 is a different area when the governor can suspend a council. And 20 says, rest are not very important for us at this stage. Otherwise, Lordship will kindly see tribal areas. Paragraph 20. Paragraph 17 has also some importance. Exclusion of areas from autonomous districts in forming constituencies in such district. So these are things which cannot be done right now. For the purpose of election to the Legislative Assembly of Assam and Meghalaya or Tripura or Mizoram, the governor may by an order declare that any area within the autonomous districts in the state of Assam, Meghalaya, Tripura or Mizoram, as the case may be, shall not form part of any constituency to fill a seat or seats in the assembly reserved for any such districts, but shall not form part of the constituency to fill a seat or seats in the assembly not so reserved to be specified in the order. So there is something relating to the delimitation and elections of other areas, but that is again not subject matter here. But I'm just indicating it. Then the transitional period, that is not required because these are not newly created areas now. Tribal areas, 20. The specified area in part 1, 2, and 3, etc. of the table below shall respectively be the tribal areas within the state of Assam, state of Meghalaya, etc. Now, part 1, Lordship will kindly see. Part 1, North Kachar Hills District, Karbi Anglong District, and Bodoland Territorial District. This was done in 2000. Lordship will see 8 by the 6th schedule to the Constitution Amendment Act of 2003 with effect from 7/9/2003. So on 7th September, Bodoland Territorial Area District, BTAD. BTAD has come into existence. A is not important, B is not important. These are relating to Mizoram. BA, which Lordship will find, discretionary exercise of powers of the governor in discharge of his functions. So certain areas where the governor's role will be discretionary and certain areas his role will be constitutional. That means under Article 163(1), which says he will have to act on the aid and advice of the state cabinet. So there are demarcations, segregation of areas where the governor will exercise his own discretionary powers or he will abide by the aid and advice of the state council. So whatever has been done till now, in my humble submission, the petitioners have failed to indicate that which provisions of the Constitution are violated by executing the third Bodo Accord. They have to pinpoint that this particular provision of the sixth schedule is violated. Their competition is second Bodo Accord and third Bodo Accord, inter se. If the earlier accord of 2003 says that what are the areas to be included in BTC, in between 2003 to 2020, lot of demand has come. We have stated in our affidavit that some people are wanting to come out of BTC, and there is a huge chunk of people who wants to be a part of BTC. Both ways. It is not one-way traffic. There were demands on either side. But government is not taking any decision. For that, the governor is empowered to constitute or make a commission under paragraph 14. That exercise has been initiated in 2020. Thereafter, it has not been completed till date because of COVID and other reasons. Once that exercise is completed, then the government will take a call on the basis of the recommendation of the governor to be placed by the HAD minister in the state assembly, to be debated in and out, and finally it will go to the central government, because for any change, the parliament has to change the constitution. There should be an amendment of the sixth schedule. We are at stage 1. In Ludo, we start the game from 1 to 100. So we are not even 10. After 100, the game will start. The cause of action will arise. That cause of action is yet to be conceived now. Therefore, this writ petition is premature in nature and it has to be dismissed in limine. It has wasted a lot of honorable court's time on several other occasions also. So next, my argument is, Lordship, that how BTC's power has been diluted. They have to indicate that the BTC will not be able to take certain decisions. Where are those? Lordship will not act in the air. They have to give a specific indication, instances of dilution of power, that the CEO, Chief Executive Officer, will not be allowed to do certain works, or whether the BTC's chief will be diluted of his power, or the power of the EMs will be diminished. Nobody is complaining. And when they were in the power, they were agreeing to it. Now, after losing the power, after losing the chair, they are finding out faults in the accord. That is why my submission, it is a politically motivated case. If Lordship, the book has come, I'd like to place those paragraphs. In 2004, 3 SCC, page 349. Ashok Kumar Pandey versus State of West Bengal. Paragraph 4.
Yes.
May I read it, Lordship? When there is material to show that a petition styled as a public interest litigation is nothing but a camouflage to foster personal disputes. In my case, I will say that personal and political disputes here. The said petition is to be thrown out. Before we grapple with the issue involved in the present case, we feel it necessary to consider the issue regarding public interest aspect. public interest litigation, which has now come to occupy an important field in the administration of law, should not be publicity interested litigation or private interested litigation or politics interest litigation. This is what I am trying to emphasize. That politics interested litigation, or the latest trend is paisa income litigation. If not properly regulated and abuse averted, it also becomes a tool of in unscrupulous hands to release vendetta and wreak vengeance as well. There must be a real and genuine public interest in the litigation and not merely an adventure of a knight errant or pokes one's nose into a probe. It cannot also be invoked by a person or a body of persons to further his or their personal causes or satisfy his or their personal grudges and enmity. Court of justice should not be allowed to be polluted by unscrupulous litigants by resorting to the extraordinary jurisdiction. A person acting bona fide and having sufficient interest in the proceedings of public interest will alone have a locus standi and can approach the court to wipe out violations of fundamental rights and genuine infraction of statutory provisions, but not for personal gain or private profit or political motive or any oblique considerations. These aspects were highlighted by this court in Janta Dal case and Kazi Landrup Georgie versus CBI case. A writ petitioner who comes to the court for relief in public interest litigation must not only come with clean hands like any other writ petitioner, but also with a clean heart, clean mind, and clean objective. So my submission here is, when the government says that all illegal encroachment will be removed from the government lands, water bodies, and forest areas, and they are challenging this, can it be a genuine and bona fide prayer, Lordship? This is sheer abuse of the process of the court. So in that view of the matter, it is to be dismissed in limine. Another judgment, Lordship. State of Jharkhand versus Shiv Kumar Sharma, 2022, Supreme Court Online, Supreme Court 1541. 2022, SCC Online, Supreme Court 1541.
1541.
1541. By my Lord Justice Uday Lalit, Ravindra Bhatt, and Sudhanshu Dhulia. Here, paragraph 15. Paragraph 25, Lordship. The locus of the petitioner which initiates a PIL is therefore of extreme importance, as this important form of litigation should not be abused by motivated individuals to abuse the process of the court for their political purposes or for any other reasons, but for a public cause. If Lordships looks at the clause title, they are all either ex-MLA, ex-MLA, ex-MP, ex-minister, ex-deputy speaker. All these are the parties. I placed it once more. If a Lordship wants, I can place it once more. Let us see who are these persons. Page 8. Page 8. One association is Bodo Writers Academy. They have nothing to do with politics. They are with development of Bodo literature and writers. If they have come singly, I would have not made this argument. If Bodo Writers Academy was single petitioner in this case. But the problem starts from petitioner number 2 to petition number 9. Sorry, petition number 5. So petitioner number 2, ex-MP. Petitioner number 3, ex-minister. Petitioner number 4, ex deputy chief executive member. They have stated that in their paragraph 6, ex-CM, that means second in command in the council. The first one was Hagrama Mahilari, he is the CM. Now it is Pramod Bodo. The second deputy CEM was Kampag Borgeri. Then Hitesh Busumatari, ex-MLA. And my friend has already told me the other day that out of the remaining, about 80% are direct active members of one political party. So in that view of the matter, Lordship, paragraph 25 is very relevant of whatever I have just placed. The locus of the petitioners who initiates a PIL is therefore of extreme importance, as this important form of litigation should not be abused by motivated individuals to abuse the process of the court for their political purposes or any other reasons but for a public cause. So there may have political differences. Political differences, political opinions may differ, Lordship. That is the part of the democracy. We cannot have any quarrel on that principle. But to express their grievance, if to express and to have to settle their political differences, the appropriate forum will be the political field, not the Honorable Court of Law. This is not the appropriate forum. For that, they have to go to the people, to the masses, fight on those principles in any election, any battle of ballots, then, or in their assembly, they can have debates. These are all persons who have access to the assembly at one point of time. So they've made, maybe they are out of power, tomorrow they will again come back. So they can debate all these things in their floor, but not in this honorable court. That is very clearly indicated by the judgments of the Supreme Court, as well as Lordships also decided on so many fronts that political grievances, political disputes cannot be resolved unless it has violated any of the constitutional provision. That handle also I am making, but they have to indicate which provision of the sixth schedule has been diluted or not followed. So paragraph 25. Lord.
You have mentioned about 2 to 5 of the petitioners there being politically affiliated. Rest of the petitioners also, you said something, but is that pleaded somewhere about the?
No, we have not pleaded.
You have not.
We have not pleaded, but everybody has come together. So if suppose Bodo Writers Academy, they have said that we have a common cause. So they have also put them into the political color. The other persons, I am giving indication is very clear. And who is signing all the affidavits? They had a meeting that the ex-honorable MP will sign all the affidavits. I placed it the other day. So it is an outright political battle being fought in this honorable court now. The surrounding circumstances. If Lordship asks the rest of the people, what is their political affiliation? They are all active political persons of one political party. So my humble submission is, Lordship, it is very clearly discernible. And some of the grounds, if one ground, Lordship, the other day I read out, that it will create political turmoil. One ground very clearly says page 84. page 84, they have used for that the detrimental political move of the government of Assam to exclude so and so. This is one. Page 90. For that the impugned MOS has been entered into for extraneous political considerations. So all these grounds are taken by all the petitioners, not only the political persons whose identity is clearly discernible. Page 95. In the middle, a shift in the political equilibrium in the BTC. All this clearly indicates that it has the component or element of political fights. One very celebrated case on PIL 2010, 3 SCC, page 402. One celebrated topic. 2010 3 SCC page 402, State of Uttaranchal versus Balwant Singh Chaupal. From paragraph 143 starts, abuse of public interest litigation. I will not trouble your lordship with all these paragraphs, but ultimately in paragraph 81, it has been summarized, all the principles of PIL. 181.
181.
Yes, from paragraph 143 onwards, but ultimately the summarization is at 181. We have carefully considered the facts of the present. We have also examined the law declared by this court and other courts in a number of judgments. In order to preserve the purity and sanctity of the PL, it has become imperative to issue the following directions. The court must encourage genuine and bona fide PILs and effectively discourage and curb the PILs filed for extraneous consideration. Here the extraneous consideration in my humble submission is political considerations. Instead of every individual judge devising his own procedure for dealing with the public interest litigation, it would be appropriate for each high court to properly formulate rules for encouraging the genuine PL and discouraging the PLs filed with oblique motives. Consequently, we request the high courts who have not yet framed the rules should frame the rules within 3 months. The Registrar General of each high court is directed to ensure that a copy of the rules prepared by the high court is sent to the Secretary General of the court immediately. Therefore, we have done it. Our high court has done it. The court should prima facie verify the credentials of the petitioners before entering a PIL. That's why I am repeatedly showing their credentials. The court should prima facie satisfied regarding the correctness of the content of the petition before entertaining a PIL. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. So here, all the stakeholders who have signed the third Bodo Accord, as well as second Bodo Accord, as well as the first Bodo Accord of 1993, everybody represents substantial group of people residing in BTC. So whoever has entered it, they are authorized at that relevant point of time. In 2003, BLT was authorized because they had a major presence in the BTC area. Later on, that shows that once they become a political party as BPF, they were at the helm of affairs. They won 3 consecutive elections. That shows the acceptance of BPF at that point of time. And they signed the second Bodo Accord in 2003. in 8th of February 2003. In 2020, the equation changed. Instead of BLT was at the helm of affairs, the NDAB's four faction came into the forefront. APSU came into the forefront. ABPO, another organization, came into the forefront. And along with them, BPF's chief was also present, other than the central government and the state government representatives. So, how can it be against the public interest of BTC? All the persons who had put their signature on the sanguine document on 27th of January 2020, they had the backing of the people of BTC. They had the support of the people of Assam. They had the support of the people of India. When the Honorable Home Minister of this country was part of it, when the Chief Executive Member of BTC was part of it, to the then Chief Minister and the one Cabinet Minister was part of the exercise, they were witness. How can somebody say this is anti-public? Because they have the support of the people behind them. They are all, most of them are elected representatives. Not all, but most of them. So it cannot be against the public. If it can be against some political interest, but political interest, everybody will have their own political interest. My friend have another ideology. I may have another ideology. But my representative, the MP of Guwahati, represents our political identity. My friend belongs to one political party. He is the vice president of one political party. I may belong to another political, although I am not a political person. We may have, but ultimately who won Guwahati seat? That will count in parliament. Or our, in the state assembly, the East Guwahati's representatives' opinion of all the people of Guwahati will be reflected in any kind of debate. We have more than 2 lakhs voters here in East Guwahati. But so 2 lakhs opinion cannot be considered. One opinion of the elected representative, that is said by the Honorable Supreme Court in the discussion on federalism. Next is Lordship. The court should ensure that petition which involve larger public gravity urgency must be given priority. 7. The court, before entertaining the PIL, should ensure that the PIL is aimed at redressal of genuine public harm or injury. Now, removing encroachers from government land cannot come under the realm of public harm or public injury. The court should also ensure that there is no personal gain, private motive, or oblique motive behind filing the PIL. The court should also ensure the petition filed by the busybodies for extraneous and ulterior motive must be discouraged by imposing exemplary cost. That is why my submission was that exemplary cost may be imposed here. We are arguing the case for last 3 days. So many other occasions of this case. By adopting similar novel method to curb frivolous petition and the petition filed for extraneous considerations. So this is regarding the maintainability. I would like to place 2-3 judgments on the point of (2011) 1 SCC page 228. (2011) 1 SCC page 228. अपना इंडिया तो नहीं इंडिया तो सर ना
আছে 100%. নাই
Hmm?
নাই মাল্টিপল মোড ফটো চলি আছে নাই চলি আছে দেখছো is given
228 page number, paragraph 6, paragraph 26. Because an argument has been made that our structure of federalism will be changed or affected. So various basic features of the constitution includes lordship, supremacy of the constitution, rule of law, the principle of separation of powers, the principle of behind fundamental rights, objectives specified in the preamble, judicial review, F is federalism, secularism, etc. Now, whatever we are doing till now, lordship, has it violated any of the provisions of the constitution? Because one of the basic feature is the supremacy of the constitution. Everything, the power has been sourced to various provisions which I have already highlighted or placed before this honorable court. That supremacy of the constitution. This accord, in my humble submission, is a political solution of the aspirations of the people of Bodo area. Various factors, long history of infightings, fights with the nation, fight against the country, fight against the state. After prolonged exercise, the first accord was signed in 1993, then 2003 and 2020, third one. And although the preamble says that this is the final solution, we do not know. In tomorrow, that scenario may change and it can have a better version of the accord also. But first, whether any of, what are the basic difference of second and third? I have already submitted, Lordship. There is absolutely no, some improvement. I would rather use the word cosmetic changes. There are some cosmetic changes there. More development projects are being allotted now. There are some administrative reforms. Few new departments has been created. More universities are being allotted. There will be station factories in various fields. There will be a superior officer coming. There will be a duty on the state government to protect the government land in BTC also. Law and order situation is still, law and order is not a transferred subject till now. So if there is a area in BTC area, Lordship, there is large scale encroachment of illegal migrants from Bangladesh. Whether BTC has the wherewithals to remove them. In that case, the state of Assam will have to step in. All the police belongs to the state of Assam. For police, whether it is in Karbi Anglong or in Dima Hasao or in BTC area or in any other autonomous councils of the state, there are several other autonomous councils, about 10 to 15. That area is with the state of Assam. So when an area has to be cleared from illegal immigrants, I have just cited one example in Mizoram border. What happened? When Assam police along with the deputy commissioners of 3 districts were there was firing from the other side. 6 policemen lost their life at the spot. The SP of Kachar, till now he has not recovered. There were bullet injuries in his leg. He'll no more be part of the police force. He's IPS officer. So in that case, Lordship, it is my humble submission that the state will have to step in. There are 10 kilometers, there were encroachment, and there were a lot of non-forest activities going on in inner line forest, reserve forest. And in Bodoland area also, there are large number of forest areas, water bodies are there. There are illegal people residing in the third areas of Brahmaputra. So this is necessary. So, but that has to be supported by the provisions of the Constitution as well as the other norms. So till now, about 40 or 48 subjects are transferred. Here also 8 more subjects are transferred now under the third accord. So till now, but law and order is not yet transferred. So police is still under the control of the State Home Minister. Next. 2024, 1 SCC, page 384. 2024, 1 SCC, page 384, State of Punjab versus Principal Secretary, Government to the Governor of Punjab and another. Here, a detailed discussion is being done on federalism and democracy, which are both basic structure of the Constitution and are inseparable. While dealing with the power and role of governor, various observations are made, Lordship, and I would like to place paragraph 15. The whole judgment is important. I'll not take much time. I promise also I'll finish before 12, but I'll try to finish before that also. Paragraph 15. The first line is very important. These are general principles, Lordship. The governor is a symbolic head and cannot withhold actions on bills passed by the state legislature. In parliamentary form of democracy, the real power vests in the elected representatives of the people. So my humble submission is that the persons who have put their signatures on the accord, most of them are, Lordship, elected representatives. The government, both in the state and at the center, consists of members of the state legislature as well as the case may be in parliament. Members of the government in a cabinet form of government are accountable to and subject to scrutiny by the legislature. The governor, as an appointee of the president, is the titular head of the state. The fundamental principles of constitutional law, which has been consistently followed since the constitution was adopted, is that governor acts as the aid and advice of the council of ministers, save and except in those areas where the constitution has entrusted the exercise of discretionary power to the governor. This principle cements the bedrock of the constitutional foundation and the power to take decisions affecting the governance of the state, or as the case may be of the nation, essentially lies with the elected arms of the government. The governor is intended to be the constitutional statesman guiding the government on matters of constitutional concern. So, as my learned friend has earlier submitted that the governor is governed by Article 161, and there one of the ground also says that governor is covered by 161. I am also agreeing to that. And in that situation, Lordship, the governor will have to act for the aid and advice of the cabinet. And whatever it has been done, Lordship, para 20 BB does not include Karbi Anglo, include BTC area. The other two, there are certain areas where the governor has a discretionary power. But in case of other areas, like constitution of the commission under paragraph 14 of the strict schedule, the governor has to act as per the aid and advice. So there is nothing wrong in the governor's decision to constitute that commission. Paragraph 17. In SR Bowman, the other side relied upon this judgment. A nine-judge bench of this court has held that the federalism is a part of the basic structure of the Constitution. The manner in which the role of the governor as a symbolic head of the state is performed is vital to safeguard the basic feature. The exercise of unbridled discretion in areas not entrusted to the discretion of the governor risks walking roughshod over the working of the democratically elected governments at the state. In steady line of cases, this court has strengthened the importance of the institutions and their vitality to democratic functioning. Federalism and democracy, both part of the basic structure, are inseparable. When one feature is diluted, it puts the other in peril. The tuning fork of democracy and the federal is vital to the realization of the fundamental freedom and aspirations of our citizens. Whenever one prong of the tuning fork is harmed, it damages the apparatus of the constitutional governance. In the state of NCT versus Union of India, paragraph 227, these cases involve vital questions about democratic governance, the role of institution in fulfilling constitutional values. The constitutional guarantees to every individual the freedom to adopt a way of life in which liberty, dignity, and autonomy form the core. The Constitution pursues a vision of fulfilling these values through a democratic polity. That is through election, the numbers, etc. These are all part of the democratic polity. The disputes which led to these cases tell us how crucial institutions are to the realization of democracy. It is through them that the aspirations of the democratic way of life based on the rule of law are fulfilled. Liberty, dignity, autonomy are constraining influences on the power of the state. Fundamental human freedoms limit the authority of the state. Yet the role of institutions in achieving the democracy is as significant. Nations fail when institutions of governance fails. The working of a democratic institution is impacted by the statesmanship or the lack of it shown in those in whom the electorate faced the trust to govern. Lordship will kindly, in whom the electorate faced the trust to govern. In a society such as ours, which is marked by a plurality of cultures, diversity of traditions, an intricate web of social identity, and a clatter of ideologies, the institutional governance to be robust must accommodate each one of them. Criticism and dissent form the heart of democratic functioning. That is why my submission is there can be political differences. Criticism and dissent form the heart of democratic functioning. The responsiveness of institution is determined in a large measure by their ability to be receptive to differences and perceptive to the need of constant engagement and dialogue. Here also all these agreements were done through several rounds of negotiation and dialogue of various stakeholders from time to time. In the last one of 2020, the dialogue started from 2013, when the BPF was at the helm of powers in BTC, other than the government of Assam and central government. Constitutional skirmishes are not unhealthy. They test the resilience of democracy. How good a system works in practice must depend upon the statesmanship of those who are in decision-making positions within them. Since these cases are as much interpreting the Constitution as they are about the role of institutions in the structure of democratic governance and the frailties of those who must answer the concerns of citizens. So here the case was basically the power of NCT and vis-a-vis the central government. But these principles are applicable here also. And the supreme authority has been given to the democratic functioning and the various institutions. Who are these democratic institutions? In our case, if you look at the agreement, one major institution is the central government. The other one is the state government. These are formed through elected representatives. Third one is BTC. Fourth one, the various other stakeholders representing the community of Bodoland. So in my humble submission, there is no conflict with the principles of federalism in the instant case. In our federalism, Lordship, the central government takes the major chunk. The main power lies with the center. That is why Article 1, 2, and 3. They can immediately dissolve two states. They can create a third state. For that, the opinion of the state of Assam or opinion of JNK will not be relevant. The center takes that Assam should be divided into 2 parts or 3 parts, or JNK should be divided into Ladakh, JNK, which has been done recently. Not very far away, about a year ago. So that exclusive authority lies with the central government. It is tilted towards the central government, but that system is there. It is not 6. It is not the equal power to all the institutions. Some has more power, some has less power. But that is the structure given us by the Constitution. We have to abide by it. And if anybody are aggrieved, Lord, they have to challenge the constitutional provisions. If the commission cannot work for taking opinions of the people regarding inclusion or exclusion of villages in BTC, the right option would be to challenge para 14 of 6th schedule, that the governor should not have this power, or should not have the power under paragraph 1, subpara 3, C, D, E, or double F, that he cannot change the name of a district council. Those powers should be challenged. The fountain of the power is the Constitution. The Constitution has made the structure, the system, and we have to fall in places. The state government cannot override the Constitution. Same way, the central government cannot bypass the constitutional provisions. What the judgment is. (1977). मुझे पूछ रहे हैं 2006-7 SCC page 1. Kuldeep Nair versus Union of India. Page 1, 2006, volume 7 SCC. Page 1, the relevant paragraph will be 50, 63, and 71. I would like to read 71. Paragraph 50, page 49, Lordship will see the heading with federalism. Paragraph 50. 50. Lot of arguments and lot of principles are discussed from paragraph 50, 51 onwards. Because the other side raised the issue of federalism. That is why I'd like to clarify. The federalism in India is not in its strictest term as it is prevailing in USA. Paragraph 50 says the Constitution incorporates the concept of federalism in various provisions, giving the demarcations, Lordship. Paragraph 63. 63. True, the federal principle is dominant in our Constitution and that the principle is one of basic feature. But it is also equally true that federalism under the Indian Constitution leans in favor of a strong center, a feature that mitigates against the concept of strong federalism. Some of the provisions that can be referred to in this context include the power of the Union to deal with the extraordinary situations, such as during the emergency, Article 250, 252, 253, and the event of proclamation being under Article 356, that the governance of a state cannot be carried on or in accordance with the provisions of the Constitution. The power of the Parliament to legislate in respect to the matters of the state list in the national interest, in case there is a resolution of the State Council of States supported by prescribed majority, Article 249. The power of the Parliament to provide for creation and regulation of all India services common to the Union and the states in case there is a resolution of the Council of States supporting by not less than 2/3 majority, Article 312. There is also one citizenship, namely the citizenship of India, and perhaps most important, the power of Parliament in relation to formation of new states and alteration of areas, boundaries, and names of states. This court in State of West Bengal versus Union of India has observed our Constitution is not of a true or a traditional pattern of federalism. In a similar vein of other judgments of the court, like State of Rajasthan versus Union of India, and that speak of the conspectus of the provisions that whatever appearance of a federal structure our constitution may have, judging by the content of the power which a number of provisions carry with them and made use of them, is in its operation more unitary than federal. The concept of federalism in our constitution, it has been held, is vis-a-vis the legislative power, as would be evident by various articles of the constitution. In fact, it has come into focus the context of distribution of legislative powers under Article 246. Then paragraph 71. Every paragraph is important, but I'm cutting short, Lordship. Paragraph 71. But then India is not a federal state in its traditional sense of the term. This is the opinion of the Honorable Supreme Court. But then India is not a federal state in the traditional sense of the term. There can be no doubt as to the fact, and this is of utmost significance for purpose at hand, that in the context of India, the principle of federalism is not territory related. This is evident from the fact that India is not a true federation formed by agreement between various states, and territorially, it is open to the central government under Article 3 of the Constitution, not only to change the boundaries, but even to extinguish a state. Further, when it comes to exercising power, they are weighed heavily in favor of the center, so much so that various descriptions have been used to describe India, such as pseudo-federation or quasi-federation in an amphibian form, etc. So my humble submission is, Lordship, agreement has been formulated and it was signed by three major entities. One represents the central government, the MHF officials was there. One, the Chief Secretary of the state of Assam. And third, the representatives of Bodoland people. Not only one organization, the major organizations who were calling the shots in BTC, and over whom the people have their confidence that they are our representative. Now, not a single entity has come out and said that why we are excluded from this exercise. Nor these petitioners can claim that. If any X organization, suppose in organization name X, they are not before this court, that we should have been asked, we should have been a part of the negotiation, we should have been a part of the signatories. That has not happened. So everybody was taken into confidence by the central government's initiative, supported by the state government, and active cooperation and participation of the BTC Council, headed by Honorable Hagrama Mohilari, who was the chief of that council. What more is required, Lordship? In that view of the matter, Lordship, this is totally a frivolous case. Few political aspirations may have been hampered or harmed. A PIL has been filed. All the prayers in my humble submission are not tenable at all in any scrutiny of judicial court, and therefore the PIL is liable to be dismissed with exemplary process. This is my humble submission. Deeply obliged. May I take leave, Lordship? I have put on the.
Wait, please, Your Lordship. My Lord, let me recapitulate, my Lord, as to what is our basic cases. Please, please.
Synopsis on page 2. Synopsis on page 3. Synopsis on synopsis. Synopsis.
Wait.
Which view of synopsis?
Yeah, I know. My Lord will kindly come to the synopsis of the case, my Lord. Para 2. Just to recap, my Lord, as to what we argued. This is our perspective. I'll deal with each and every point which my learned friend Mr. Saikia has argued, my Lord. This writ petition is being filed because certain issues relating to rights of the Bodos, which are recognized and guaranteed by peace accord as well as constitution, have now been sought to be taken away. This has been done by executive orders, which directly and substantially affects the rights of the people and is contrary to the law laid down by the Honorable Supreme Court in Ramjawa Kapoor's case. Then see next page. From the attending facts, it does transpire that such right which inhere in Bodo people and in Bodo territories are being gradually clipped had to take away the very autonomy which was guaranteed by the second Bodo Accord and the constitutional dispensation. Certain offending clauses of the tripartite memorandum settlement signed on 27th of January 20 is also being assailed, which are basically so and so. So these are the offending clauses which we are putting to challenge. Now, if your lordships would kindly come to E, there are also a series of notifications which have a deleterious effect on even what was guaranteed by second Bodo Accord. This has been done in the following way. So these are the major heading, my lord, on which our writ petition has been structured. But basically what we seek to contend is, my lord, following the second Bodo Accord, the constitutional amendment took place and BTAD was envisaged as a sixth schedule area. As a sixth schedule area, my lord, the Bodoland BTAD as well as its people enjoyed certain rights and privileges. The whole idea is devolution of power. Idea is self-rule. Bodo people will not be governed by dispute. Bodo people will be governed by Kokrajhar. That is the idea. That is what, in constitutional sense, we say separation of power. My learned friend, towards the end, he referred to one judgment, my lord, 2011 1 SCC 228, para 26. The first 2 points is, my lord, supremacy of the constitution and separation of power. These are constitutional principles. These are constitutional ethos. These are non-negotiable. Forget of, my lord, executive instruction, even by constitutional amendment under 368, these essential features cannot be amended. And by executive power, you are seeking to take away our rights. Therefore, what we are for is, my lord, the first and the second Bodo Accord recognizes our right of self-rule. Now that the dispute cannot dilute by these superfluous means. These are all subterfuge. Right of self-rule, which has been guaranteed by the constitution, that cannot be taken away by mere executive fear. That is our case. So in such a scenario, my lord, to argue that the petitioners do not have locus standi is, my lord, is an utterly misconception. My lord, when Sarbananda Sonowal challenged IMDT Act, State of Assam and Union of India raised a plea that this gentleman does not have locus standi. In para 83, Supreme Court said, my lord, it is not only his fundamental duty, it is the fundamental duty of every citizen to bring such constitutional infirmities to the notice of the court. My lord, my learned friend referred to the decision of, my lord, 2024 1 SCC 384 para 15. My lord, these governors, they were acting as agents of central government. That's why Supreme Court said, you cannot withhold the bill of the states. Indirectly, what Supreme Court has said? Supreme Court has recognized separation of power. You governor, you do not have business, you have no business to withhold over the bills. Give assent to the bills. And that judgment is being cited. It helps us. By all means, this citation helps us. These are all constitutional adjudications. These are not ordinary, my lord, some Article 14 violation cases. It has to be addressed with lot sense of responsibility. These are very sensitive issues, my lord. These are not to be, there's nothing political. Yes, even if there is political, my lord, I'll just place one passage. My lord, lordship knows that DC Wadhwa's case, 87 1 SCC 378, as the famous case, my lord. 1987 1 SCC 378.
So,
Please come to para 3.
not noted by them, article of the constitution.
It's a constitution bench judgment, my lord. Lordship knows this DC Wadhwa is a very famous case where Governor of Bihar, he was promulgating ordinances one after another in exercise of power under Article 2130. It was in that context, this gentleman DC Wadhwa instituted this writ proceeding, my lord. Eventually, the constitution bench had to decide. Para 3, at page 383, it was contended on behalf of the respondent that petitioners had no locus standi to maintain this writ petition, since out of the 3 ordinances challenged on behalf of the petitioners, 2 of them, namely Bihar Forest Produce Regulation and so, had already lapsed and their provisions were enacted into acts of legislature. And so far as the 3rd ordinance, namely Bihar Intermediate Education Council, 3rd ordinance was concerned, a legislative proposal was already introduced for enacting its provision into an act. The respondents also contended that petitioners are not entitled to challenge the practice prevalent in the state of Bihar of repromulgating ordinances from time to time, since they were merely outsiders who had no legal interest to challenge the validity of this practice. So basically, this was the contention. Now, kindly see, please come to the last sentence, my lord. In SP Gupta versus Union of India, one of us. Oh, I'm sorry, my lord. I'm sorry, my lord. I'll skip few lines. A line about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Line about 15 from bottom, my lord. Sentence starting with besides petitioner number 1. Yes. Besides petitioner number 1 is a professor of politics. Has a lordship got it?
Yes.
Yes. Besides, petitioner is a professor of political science and is deeply interested in ensuring proper implementation of the constitutional provisions. That's what we are also insisting upon. He has sufficient interest to maintain a petition under Article 32, even as a member of public, because it is a right of every citizen to insist that he should be governed by laws made in accordance with the Constitution and not laws made by the executive in violation of the constitutional provisions. Precisely our case, my lord. Of course, if any particular ordinance was being challenged by petitioner, number 1, he may not have locus standi to challenge it simply as a member of public, unless some legal right or interest of it is simply as a member of public, or interest of his is violated or threatened by such ordinance. But here what petitioner number 1 as a member of public is complaining of is a practice which is being followed by the state of Bihar of representing the ordinances from time to time without any provisions being enacted into acts of the legislature. It is clearly for vindication of public interest that petitioner number 1 has filed his writ petition, and he must therefore be held to be entitled to maintain his writ petition. In SP Gupta versus Union of India, one of us, Bhagavati ji, as was then observed, any member of public having sufficient interest can maintain an action for judicial redress for public injury arising out of breach of public duty or from violating some of the provisions of the Constitution or law, and seek enforcement of such public duty and observance of constitutional legal provision. Now, this is very important, my lord. The rule of law constitutes the core of our Constitution, and it is the essence of rule of law that exercise of power by the state, whether be it a legislature or the executive or by any other authority, should be within the constitutional limitation. And if any practice is adopted by the executive which is in flagrant violation and systematic violation of the constitutional limitation, petitioner number 1 as a member of public would have sufficient interest to challenge such practice by filing a writ petition, and it would be a constitutional duty of this court to entertain the writ petition and adjudicate upon the validity of such practice. But after this, to lay a challenge to our locus, I think, my lord, it's too much. It's too much. And one more judgment, my lord. B.R. Kapoor, 2001, 7 SCC 231. It's a small para 53. This takes care of political thicket also. Assuming somebody comes with a political, background also, then also it is maintainable. It's a constitution bench judgment, both. My lord will kindly come to page number 301, para 53. It was submitted, para 53. It was submitted that we should not enter a political thicket by answering the questions before us. The question before us relates to interpretation of the Constitution. It is the duty of this court to interpret the Constitution. It must perform that duty regardless of the fact that the answer to the question would have a political effect. Even if it ensures or entails a political effect, the moment an interpretation of Constitution is an issue, then, my lord, the court, it's a duty of the court to adjudicate that issue. But merely because a question has a political complexion, that by itself is no ground why court should shirk from performing its duty under the Constitution. If it raises an issue of constitutional determination, every constitutional question concerns the allocation and exercise of governmental power, and no constitutional question can therefore fail to be political, so long as a question arises whether an authority under the Constitution has acted within the limits of his power or exceeded it, it can certainly be decided by the court. Indeed, it would be its constitutional obligation to do so. It is necessary to assert the clearest possible term, particularly in the context of the recent history, that Constitution is a suprema lex and the paramount law of the land, and there is no department or branch of the government above or beyond it. So, my lord, the Constitution is the supreme law. The moment, my lord, a question arises whether a particular action is in infraction of the constitutional mandate, then it is the duty of the Constitutional Court to look into it and adjudicate. Otherwise also, my lord, I'll give an example, my lord. Supposing, my lord, I think they've come to we are the persons who are part of the first accord, second accord. That's why I think we have got sufficient locus. All that we are trying to say is what was given by second accord, we were trying to take it. So in such a scenario, to contend that we do not have a locus is something very absurd. So therefore, I don't think, my lord, this matter requires any further consideration. It's a matter, my lord, where we are raising a very core constitutional issue. Therefore, as a constitutional court, my humble submission is possibly adjudicate the matter on merit. Now, my lord, Lordship, we all know one thing by now. There is no such difference as such between a writ petition and a PIL. In both the proceedings, the petitioner comes for enforcement of the right. In a personalized writ petition for his personal right, and in a PIL, my lord, the right of the common people or a marginalized section, etc., etc. That's why it is said, only distinction is in case of a PIL, the rule of locus standi gets relaxed. Otherwise, my lord, there is no such difference. Both are proceedings under 226. One is filed by an aggrieved person, and the other class of petition is filed by a person who necessarily need not be an aggrieved person. He can represent the cause of somebody else. But here, my lord, in all the petitioners as Bodo, we are all agreed by this because our autonomy is being tinkered with, which is guaranteed to us by the constitution, by my lord, an executive order, in violation of the strict principle of separation of powers. So therefore, my lord, this is an aspect. I don't think lordships will require to devote much time, my lord. Now, just before rising, my lord, I was trying to point out one thing. I was trying to give an example. Supposing, my lord, an income tax department, they harbors a suspicion that Mr. X is in possession of unaccounted money. Based on that satisfaction, my lord, a charge is conducted. That person whose premises is charged on the suspicion that he is holding some unaccounted money, he files a writ petition before the High Court. Now, what the High Court examines, my lord, that satisfaction. So these are always judicially reviewable, my lord. These are always judicially reviewable. Now, some of the satisfaction in this case, which the authority has, my lord, recorded before passing the impugn order, these are all subjective satisfaction. So whenever these subjective satisfactions are put to challenge in a 226 proceeding, my lord, it is judicially reviewable. From whatever angle, my lord, we view at these matters, to contend that there is no locus standi, in my humble submission, is not correct. Then, my lord, an argument was made by my learned friend that writ petition is premature because the commission is yet to come out with the report. That land commission, boundary commission. Now, here, if your lordships would kindly take the Constitution for a moment, my lord. 6th schedule. Para 14. My lord, I have my doubt. The exercise which is being attempted, whether it falls within the ambit of 14, but I am not troubling your lordships with that. Assuming, my lord, 14 does empower the governor, my lord, to undertake an exercise as it being sought to be taken, let us read it and try to find out what is the purport. The governor may at any time appoint a commission to examine and report on any matters specified by him relating to administration of the autonomous district, autonomous region in the state, including matters specified in clauses C, D, E, and F of paragraph 3 of subparagraph 1 of this schedule, or may appoint a commission to inquire into and report from time to time on administration of autonomous district and autonomous region in the state, generally in particular on educational and medical facilities, need of any special legislature district, and administration of laws, rule, regulation, etc. Now, 2 is important. The report of every such commission with recommendation of the governor with respect thereto shall be laid before the legislature of the state by the minister concerned, together with an explanatory memorandum regarding the action proposed to be taken thereon by the government of Assam. My lord, an argument is sought to be developed that what is wrong in it. Writ petition is premature because that exercise is going on. We have not even completed. Now, what the state have done, my lord, or lordship will find. We could lay our hands only day for yesterday, my lord. Therefore, we could not brought it by way of any affidavit. Now, without laying in the legislature, my lord, they have implemented. They have included some villages. Where is the question of premature? That means, my lord, our apprehensions were correct. In exercise of the power conferred as per clause 1(3)(d) and G of the 6th schedule of the Constitution, and after due consideration of the interim report submitted by the Commission of Alteration of Areas included under BTR, constituted by dated so and so, Governor of Assam is pleased to accord approval to transfer 11 villages from Dorong district to Udalguri district and transfer of 10 villages from Nalbari district to Tambulpur district as detailed below. So, my lord, without laying it before the assembly, my lord, they have already given effect to.
Yes. I was in this.
Yes, I've given a copy, my lord.
And all these villages are approved.
And my lord, incidentally, what we have been instructed to submit before lordships, these villages are majority non-Boro villages, my non-resting population village. Anyway, that's besides the point. Therefore, their submission that it is premature is not correct. They have already acted on it. Now we'll show why they could not have acted on it. End of the day, on merit, our endeavor would be to satisfy your lordships that in undertaking the impugn exercises, there is a constitutional violation. Then only lordships can interfere. So therefore, this argument also does not hold any water. Then, my lord, an argument was made that third accord will be followed by constitutional amendment. How can my lord, a law officer of a state can make this submission, my lord? Well, I'm on the propriety part. Parliament, central government, Attorney General, these are all there, my lord. I do not know whether my learned friend is instructed to make that submission, but it is somewhat abhorrent, my lord. It's not done. And therefore, lordships will not take judicial notice of such submission. When it comes to it, we'll see. When it comes to the crossing the bridge, we'll see how to do it. You have not done it. You cannot fortify your case by bringing in a plea which is not even, my lord, is bond. This is neither here nor there. And my lord, this accord was
Let's just have a look at the notification that constituting that commission committee.
yes, this one, my lord. Just now one I have given.
Yeah,
Yes.
No. Apart from the, it's in the writ petition.
Yes, yes. Yes.
Yeah.
Annexure 7, my lord. 174.
174. Oh, sorry.
Yes.
No. 175. 170.
175.
Annexure 8.
This is not-
8. In pursuance of clause 3.1 of the Memorandum of Settlement signed on 27/1/20 by Government of India, Government of Assam, All Bodo Students Union, and DFB, the Governor of Assam is pleased to constitute a commission under para 14 of the 6th schedule of India with the following members for alteration of the areas of so and so. So, EP Verma, then Administrator BTC, Jayanto Bosumotari Vice President. Then, my lord, who is this Dalim Bayan? I don't know, my lord. Joint Secretary to the Government of Assam, etc.
But this is not a commission that is reflected in this notification.
This is the commission, my lord.
Notification from Petitioner. 29/9/2020.
Kindly see, my lord, it refers to their notification dated 29/9/2020.
This
This is 28.
28.
But there is a same.
But it's same, my lord. Anyway, let them clarify their position. But our information is, my lord, it is the same commission which has done it. Now the question is whether they could have done it. I'm coming to that.
But it's only commission.
Yes. I don't think there is any other commission. Maybe, my lord, there's some printing mistake or
Sir, এইটো কৈছে তেওঁলোকে নিজৰ হেৰি 277 পেজ নম্বৰত অলপ পঢ়িলে যে এইটো তেওঁলোকে চেঞ্জ কৰিছে তেওঁলোকে এইটো হেৰি এইটো কৈছে আলটিমেটলি এইটো
Notification number to 8.
নাই কিন্তু এইটো 29ত কৰিছে 29ত কৰিছে
oh yes. My lord will kindly come to the affidavit. My lord will kindly come to 277
Page.
of their affidavit. Yes. This is 29.9.
Notification number 20.
Hmm.
54.
Hmm. In pursuance of clause 3.1 of page 277. Hey, I see to slide it. 38, my lord. Annexure 38. It 38 দেখা যায়।
No, that is I.
Annexure 1, I think. Yes. This is 29.9, my lord. In pursuance of clause 3.1 of the memorandum settlement on with Bodo organization and DFB, the governor is pleased to consider a commission under so-and-so with the following members for alteration of the area. So there is a requirement of my lord laying it before the assembly. To our information, my lord, it has not been done. We have also checked from the assembly records. It is not there. And plus, my lord, that gentleman is no longer there also. Mr. Verma has expired.
This is in pursuance of this committee.
Yes. Actually, my lord, possibly the original was 28.9. Then it was
underneath page 277,
yes.
the last line.
Sir. Last sentence, my lord.
Last sentence.
The yes.
So,
Hereby stands cancelled. So it was, superseded. Yes. So, my lord, these are some of the points which my learned friend argued. Now, another argument was advanced by my learned friend. Since these are all in the realm of preliminary objection type, therefore I am dealing with it before I come to the merit. Now, he says, my lord, earlier it was WPT-BC department, Welfare of Plain Tribes and Backward Classes department. Now, it is Boroland Welfare Department. Now, the state's contention was, what is wrong in it? We are taking a very holistic approach to the whole problem of the tribals. Therefore, what's wrong in it? My lord, the problem is jurisdiction. Problem is outside BTR, you do whatever you like. We are not interested. We can't be interested also. Of course, as a resident of the state, we all seek the welfare of the people of the state, but that is in general. But in particular, we are concerned about welfare of our community and BTR area. So therefore, my lord, you as a state, you cannot usurp upon our powers. You have already devolved our powers. You have delegated to us. Not delegated, ceded. Now you cannot encumber that. So therefore, my lord, these arguments are neither here nor there. The 40 subjects which has been transferred, this is absolute. My lord, kindly see one thing, my lord. Under the Constitution, my learned friend has made a submission that federalism in its original sense is prevalent in USA and India it is not. He is correct. He was referring to a Supreme Court judgment there, he is correct. But nevertheless, my lord, ours is a federal structure. That is why in the 13 judges Honorable Constitution Bench of Keshavananda Bharati, Honorable Supreme Court amongst others has said that federalism is one of the basic structure of the Constitution. We cannot run away from that. As a Union of India, your power is over field enumerated in list 1 and list 3. As far as 2 is concerned, it is ceded to the state. Either cannot encroach upon. Only in case of, my lord, subjects covered by concurrent list, my lord, where parliamentary legislation has a pivotal role, my lord. In case a state legislation is repugnant to the parliamentary law, to that extent, unless it is saved by 254(2), it will be banned. Similarly, my lord, though, my lord, we are not covered by list 2, but we are covered by, my lord, 6th schedule, para 3B. The 40 subjects has been transferred. That's why I said, my lord, unlike in the Constitution where Article 356 is there, in a given situation, a government of the state can be, my lord, suspended. It can be placed under, an assembly can be placed under animated suspension. The functions will be taken over by the parliament. Such a provision, similar provision does not exist in, my lord, as a sixth schedule. Therefore, my lord, yes, certain powers are given to governor, where, my lord, governor doesn't act as a constitutional governor. There the governor act in his personal capacity, in his discretion. But a provision similar to 356 is not there. Therefore, my lord, the devolution of power, in my humble submission, subject to what your lordships may say, in a sense is absolute. Now, if you want to tinker with it, the source you must stress. You must say, this is the provision in the Constitution which permit us to tinker with your functions. That's why I'm doing it. Other than, my lord, referring to some political statement, I could not hear anything. And we made a very substantial argument based on Article 62. There is no reply to that. 162. There is no reply to that. So therefore, my lord, now let me deal with another point which my learned friend has dealt with, my lord. Please come to page 158. What an analogy has been drawn, my lord. My lord, as far as law and order is concerned, as far as prerogative of the state to deal with the issue of illegal immigrant is concerned, who is questioning him? Do whatever you like. Please clear Kokrajhar district, you will be very happy. But you can't do. Because you also do politics. You are now trying to win them. All along, my learned friend was talking of politics. Who is doing politics in this country? Everybody is seeing, my lord. Please come to 158, 7.2. Government of Assam will take effective measures to protect government khas land, grazing land, and water bodies from illegal encroachment. Now, what is this, my lord? This is the third accord which is under challenge. We say and will demonstrate they cannot do this. That is our case. This is without jurisdiction. Now, my lord will kindly take the Constitution for a moment. No. We don't, otherwise, my lord, we have no issue. Please deal with the issue of foreigner. Personally, I'll be the happiest person. Please come to, my lord, paragraph 3B, 6th schedule. Please come to, my lord, 3B. Additional powers of Bodoland Territorial Council, kindly see, to make laws. As your lordships got it, my lord. 3 capital B. Additional powers of Bodoland Territorial Council to make laws. Without prejudice to the provisions of paragraph 3, the Bodoland Territorial Council within its areas shall have power to make laws with respect to, please come to serial number 9, forest, Roman small 9, my lord. This was inserted in the Constitution with effect from, my lord, 2003. Sorry. Roman 9, my lord. Yes, Roman 9, forest. Has your lordships got it?
Yes.
Roman
Yeah.
9, my lord.
Yes.
Yes. Then come to Roman 15. Land and revenue. These are the transferred subjects. Now, you having transferred the subject, you have having ceded the power, where on earth you have the power to make that provision 0.7.2? These are all constitutional adjudication, my lord. Merely because you are state of Assam, you do not have any special power. You are also bound by the same constitution as we are. When you say we have no locus standi, we can also say you are acting without authority of law. So, my lord, our case is very simple. They have embarked upon an area which is not meant for their exercise of power. Huh? Now, my lord will kindly come to Article 162. Now, please come to appreciate our argument. Please come to Article 162. Subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which legislature of a state has power to make laws. So, executive power of the state is coterminous with that of the legislative power. So, with regard to Borole BTR, my lord, by the second OM and by the constitutional amendment, this 40 subject, including forest and land, has been transferred to BTR. You have not retained any power. There is no residuary power. There is no residuary entry, which should enable you to make or even tinker with it. Forget about anything else. So, my lord, a constitutional guarantee is sought to be diluted by a, my lord, executive exercise of power, executive fiat. Now, to further buttress my point, my lord will kindly come to section 3, clause 3B.
Planning and development.
Clause
Para 3, my lord.
Clause 3B.
3B.
Planning and development.
Same 3B, my lord. My lord will kindly come to Roman 22. Roman 22, planning and development. Then please come to last entry, my lord, Roman 40, welfare of plain tribes and backward classes. Now please come to para 12. Para 12. Kindly see the heading is very significant, my lord. Application of acts of the parliament and legislature of the state to autonomous district and autonomous region in the state of Assam. Notwithstanding anything in this constitution, it starts with a non-obstante clause. Kindly see, my lord. No act of the legislature of a state in respect of any matter specified in paragraph 3 of this schedule, as matters with respect to which district or regional council may make laws, no act of the legislature of the state prohibiting or restricting so-and-so shall apply to the autonomous district or region, unless in either case district council for such district or having jurisdiction over the region by a public notification so direct, etc., etc., etc. The extent of autonomy in respect of, my lord, transferred subject is absolute. Lordship knows all fundamental rights are not absolute, but rights under fundamental rights under Article 29 is absolute. Jagdeep Singh Siddharth, the Supreme Court had said. So this is going by the language because it starts with a non-obstante clause. Kindly see, I'm reading it once again. Why we are saying state of Assam has no power? No act of the legislature of a state, forget about executive field. Even if state of Assam wants to make a law, primary legislation, they cannot. In respect of any of the matters specified in paragraph 3 of this schedule. Here 3b. So my lord, in respect of land, in respect of all other 39 subjects, in respect of which state of Assam cannot exercise legislative power. So when they do not have legislative power, how can they exercise executive power? Because to exercise executive power, you must invoke Article 162. On the contrary, 162 says that your executive power is coextensive with legislative. And field where legislature can make a law, thereby invoking 162, you can bring an executive instruction. But where you cannot even make a law, power being coextensive, how can you do it? So that's why we are saying, my lord, the impugn notifications are ex specie without jurisdiction. That's why, my lord, when we moved the Honorable Supreme Court this petition, my lord, what was observed by the Honorable Supreme Court was, we would like to have the views of the High Court in this case. That's why liberty was given to us to move the High Court. We initially filed a petition under Article 32. The locus and all aspects were, my lord, out of question. The Honorable Supreme Court bench said, since these are all local matters, we'd first like to have the views of the High Court. That is how liberty was given. We withdrew the petition and came up before elections. Right. Which? Yes, to God, yes, to God. 199, yes, 199, no?
The deputy government responsible for oversight supervision as further, they will prepare annual action plan.
देखिए
1300 precedent লাগছে তো। আর 1300 আমি কি করি? কত সফটওয়্যার করি? ওকে পার্টি সব সাথে প্ল্যান করি। পার্টনার
Now, my lord will kindly come to page 199. Now, these are the this is one of the amongst others, one notification which we have challenged. 4th of June 2021. 199, my lord, Annexure 11.
This impugn.
Yes, one of the impugned, my lord. In pursuance of the transferred subject vested with the Bodoland Territorial Council, by 6th schedule to the Constitution and by notification dated issued by Personnel Department, Government of Assam, relating to implementation of the Memorandum of Settlement signed on 27th of January 2020, Deputy Commissioners of Kokrajhar, Sirang, Baskha, Udalguri are hereby entrusted with overall monitoring and supervision of the schemes pertaining to the following subjects entrusted to the BTC. So these are the subjects. Then please come to the subpara towards the bottom. Deputy Commissioners will be responsible for oversight and supervision for the district and subdivisional level official regarding implementation of various schemes by Government of India, Government of Assam, and BTC authority for above mentioned subject. Further, they will prepare an annual action plan and get it approved by Principal Secretary BTC with respect to subjects entrusted above for the purpose of their performance appraisal to be forwarded annually to the Personnel Department, Government of Assam. Now, my lord will kindly come to para 13 of 6th schedule. if para 13, a function which has been entrusted to the, my lord, BTR now is thought to be indirectly taken away. Yes. Estimated receipts and expenditure pertaining to autonomous district to be shown separately in the annual financial statement. The estimated receipts and expenditure pertaining to an autonomous district, which are to be credited to or is to be made from the consolidated fund of the state, shall be first placed before the district council for discussion. Then after such discussion be shown separately in the annual financial statement of the state to be laid before the legislature of the state under Article 202. Now, my lord, preparation of budget, etc., eventually it will be approved, laid before the assembly. But before that, it is the district council who will approve it. Now, my lord, now everything has been, why do we need this council now, my lord? We don't need. All these deputy commissioners are good enough. And deputy commissioners are, my lord, agents, sorry, are officers who are outside the control of us. We have no control over them. And they will supervise our activities. My lord, end of the day, how do you recognize this doctrine of separation of power if this is your attitude? You can't. So, end of the day, what we are saying? What we are saying is, by invoking Article 162, what you can do is something which state can do by law. When state cannot do something by law, can you do it by an executive fiat? In other words, what cannot be done directly, can it be done indirectly? This is our simple case, my. So we are not saying anything else. All we are saying is, second Bodo Accord, followed by the constitutional amendment, recognizes our right of self-rule. There is a devolution of power. Now, if at all anything is to be done, perhaps by a constitutional amendment, it can be done. But that constitutional amendment has not come as yet. And it will not come out. It is going to stay, my lord. So therefore, these are all colorable exercise of power. End of the day, my lord, rule of law has become a casualty at the hands of some hungry politicians. They want to yield more power. This should not be permitted, my lord. It's a constitutional court. Lordship will protect the rights of the citizens. Yes, my lord. Article 32 stands in a slightly different pedestal in the sense Article 13 itself is included in the fundamental right chapter. That's why Supreme Court has said it is a fundamental duty of the Supreme Court to protect the rights of the citizens. In respect of 226, it has not been said. But nevertheless, my lord, the fundamental right of the petitioners before lordships and legal rights are violated. They have come for enforcement of that right. We have not come here to establish right. We have come here to enforce our right. And kindly see, my lord, page 155. And kindly come to page 155, my lord.
See the objective.
When they prepare the impugned memorandum of settlement, what they profess and what they do. Kindly see the first objective: to augment area and powers of BTC and streamline its function. Are they augmenting or they are curtailing? So therefore, my lord, I'll not make my reply any longer, my lord. I have dealt with each and every point raised by my learned friend. The two decisions cited today in support of the plea of no locus, absolutely, my lord, is of no help to the state. Rather, it helps our cause, because there the Supreme Court has emphasized that there are certain facets. For example, supremacy of the Constitution, separation of judicial, separation of powers, These are non-negotiable. Whenever matters with such, complaint comes, it is the duty of the Constitutional Court to enforce the rights of the citizen. So, my lord, in the name of augmenting our powers have been curtailed. We are Bodo people. Constitution has given us a right of self-rule. There is a constitutional mechanism to do it. That is delineated in the Constitution. Let that prevail, my lord. Let state of Assam not poke its nose in our affairs. Yeah, there are areas where state of Assam can poke its nose. Please do that. My lord, for a moment, we are not against expulsion of illegal migrants. We are not against any land reform measures. We are not against economic development of this state. We are all for it. In fact, we all stand for it. So these are my humble submission, my lord. Huh? So, my lord, no, my lord. Maybe during the course of the hearing, I may have used that. Yes. Transfer. So, my lord, in case of any conflict, the Constitution will prevail, my lord. No. But let me check up, my lord. Yes. I think, my lord, in case of entrustment, maybe some residuary part may be there. But in case of transfer, it's a case of ceding. Huh? Okay.
Which follow the second letter.
My lord will kindly come to page 146. Kindly come to 146, my lord. This was the to MOS second.
This followed the second.
Following this second agreement, my lord, this was the office memorandum. Whereas in pursuance to the memorandum of settlement reached between Government of Assam, Government of India and BLT on 10th of February 2003 in New Delhi in presence of Deputy Prime Minister of India, it has been agreed to create Bodoland Territorial Council in the framework of the amended 6th schedule of the Constitution, whereas Government of Assam via notification adopted and approved the said MOS and resolved to extend executive power to 40 subjects, departments listed in so-and-so, and whereas Government of Assam has been pleased to entrust and delegate the functions dated so-and-so of the and to which executive power of the state extends. Now, therefore, following the administrative procedure and modalities are framed by the state in consultation with Bodoland Territorial Council for the purpose of day-to-day administration. My lord, this was followed by constitutional amendment. So, but in the Constitution, the expression transferred is
Same subject.
same subjects, my lord. Yes, these are the subjects. These are the subjects, 3B, my lord.
Same subject.
These are the same very subjects.
Same subject. It should be there. Sorry, to the heading. Same subject.
Same very subjects, my lord. Yes. Stands transferred. So therefore, my humble submission is, my lord, it's a very important, my lord, and it's a thought-provoking subject, and I will respectfully submit, my lord. Lordships will pass a judgment which will uphold the autonomy, my lord, and the constitutional value. That's my humble submission.
Yes.
And my lord, what we propose to do, we'll supplement our written argument. We'll supplement by a written argument.
Yes.
Maybe 2-3 days time we'll give it.
Lordship, the learned advocate general will give a short reply But before that, Lordship, I pray that the notification dated 31st December 2022 may be brought in the form of pleadings, Lordship, because we have to give a reply to that also, Lordship, since it has been placed today.
We'll do that. But my lord, what is reply of reply, my lord?
Yeah.
We'll have a right of
Because
reply.
the Advocate General will reply on this as well.
Only that's all, yes.
No other reply.
Lordship, on this, Lordship. So, Lordship, it may be brought in the form of a pleading. Lordship.
Okay, we'll bring it tomorrow. We'll file it tomorrow, my lord.
Lordship, I think the matter on Monday, Lordship.
No, let it be on Friday, we'll file it.
Lordship,
Or Lordship may keep it at maybe towards the end or in the very first start.
Lordship, the Advocate General has some other engagement on Friday, Lordship. Therefore, on Monday, Lordship, if it's convenient for Lordships.
Better have it on a hearing day, that way, because on a miscellaneous day,
Well, any date convenient to Lordship.
but Mr. K. N. Chaudhary, let us take a call. That's Mr. M. Gupta. Then call. So hard to please like it. On top. Assisted by
Yes, sir. Thank you. Yes,
Mr.
sir.
Rava,
Thank you. Thank you.
Standing Counsel, BTC.
Yes.
Mr. Architect. Are you making any submission? Architect Chaudhary, sorry. Okay, the next is you pay it here. You are intervener? Do we have interveners here? What is that?
Well, note to রাখিবা দেই।
Intervener?
আপনার অবধি আমার নথি আছে।
Do we have interveners? I don't think so.
He's
No,
was
my
allowed.
lord, I have no objection, let him intervene, my lord.
No, that petition was allowed.
No, I think they are not respondent, I think intervener, intervener, not as a respondent.
And Mr. D. Deore, the counsel for the interpreter. 11 to 20. That is not correct here. There's no correction here. Have you filed an amendment? But who are you? Who are the interveners?
Perhaps they are supporting the third account.
So you have anything to say? Okay, the next is 13 part, please for further hearing again of when do you want?
29th of October, sir.
29th, my lord. 29 নহব শ্বিলং।
Okay, 29 is my birthday.
Even I have some difficulty. No.
Then?
Any date after that, my lord. Convenient to your lordships.
After 29.
Yes.
Then 5th March.
Okay.
5th March. In the meantime, the petitioners also come to file and bringing on record.
কোন গেলা?
The notification.
ওহো, 1 তারিখে লইল না?
Petition form.
মানে 1 তারিখে।
Yes, Lordships. 30th December.
30 December 2020.
My lord, the 5th, my junior says, my lord, there is some more cases. Could it be on 4th, my lord? Will not take long, my lord. 4th.
Lordship will excuse my appearance of the next day. I started with that.
Do you have another copy of that notification?
Yes,
we have.
I was just going to somewhere. Oh, yes, no, I have.
Okay.
I have.
ভালো আছে। মোৰ ফাইলত না এখন দি দিয়া এফিডেভিটত তো আহিবই
কথাতে থাকক।
Meantime, we filed the
My
affidavit.
lord,
I've given you the purpose.
Thanks, Your Lordship. Lordship, I beg to mention for listening of the matter pertaining to transfer on 23rd of this month for withdrawal.
Withdrawal.
May I please, Dr. I would like to mention also two writ petitions. One is related to compensation and appointment, and another is selection and appointment of Gaugula. One is listed July 2023, and another is December 2023. So 11 March, Lordship. Both of
Okay.
11 March.
May I please, Your Lord? Lord, I beg to mention, my lord, item 16, my lord. Due to some, my lord, subsequent development, my lord, I want to withdraw this petition, my lord. With the lever.
Mr. R. Ali.
Lord.
Then it comes to for petitioner, press for withdrawal of this writ petition with liberty to file afresh. Anybody appearing for the respondents?
Government, my lord.
Government advocate, Mr. J.K. So Leonard Government advocate appears for the state. Writ petition is dismissed on withdrawal with liberty aspect.
Obliged.
May please, Your Lordship. I beg to mention item number 64. This matter may be adjourned for the day, Lordship.
Yeah, for
I am on behalf of Mr. Soilendra Kumar Dekka.
on request made on behalf of Silendra Dekal and a counsel for the petitioner. Released after 1 week.
Yes, Lord.
After 1 week.
Lordship, in fact, we have to take press steps on respondent number 3 and 5 in this case. So it may come after 4 weeks. In the meantime, we shall take the steps, Lord.
Released after 4 weeks.
Obliged, Lord.
May it pleases Your Lordship, item number 53 may be adjourned for 2 weeks.
Item
Item number 53. As we need time for 1 week to file and counter affidavit.
yeah for the
Respondent,
have you informed the petitioners counsel?
yes, we have taken consent from petitioner.
Okay, on request made by MS.
I'm on the behalf of BKC. FCA. Oh, my name Priya Tiwari.
On request made on behalf of Mr. BK Singh, London Standing Council FCA, released after 2 weeks. Yes.
May I please, Your Lordship? I beg to take adjournment for item number 9, Lordship.
Why?
Lordship, there have been some subsequent developments. We need to obtain instructions from the client, Lordship. Matter may be taken up after
Yeah, MS.
B. Mohanto, Lordship.
Item 9.
Yes, Lordship.
Your name is not here. Okay, on request made by MSP Mahanda, London Council for
B.
petition. Petitioner,
Yes, Lordship.
list after
2 weeks, Lordship.
2 weeks.
May please, Your Lord.
Much obliged.
May please, Your Lordship. Lordship, I pray to listing of the matter, Your Lordship. It's in regard to pension, Your Lordship. So may I pray on Monday it can be listed, Lordship.
Monday.
Monday will be Lordship 26th, Your Lordship. Or maybe on Wednesday then, Lordship.
Wednesday will be better. 28.
Wednesday, 28th. And Lordship, one more prayer, Lordship, regarding item number 26, Lordship. So taking consent from the other side, Lordship, I am appearing on behalf of Mr. D. Dekka. So he has some personal difficulty, Lordship. So the matter may be adjourned for 2 weeks, Your Lord.
Okay, on request made on behalf of Mr. D. Dekal and the counsel for the petitioner. List after 2 weeks.
Not okay.
May I please, Your Lord? May I please, Your Lord? My lord, I am praying for listing of a writ petition, my lord, next week, my lord. On 28th, my lord.
Okay.
May I please, Lordship? I'd like to mention for withdrawal on tomorrow.
May it be day after tomorrow. Tomorrow will be difficult.
May I please, Your Lordship? Lordship, I beg for Lordship, item 27 to 30. But kindly matter may be adjourned for the day. We have taken consent of the other side.
You have 40?
For the petitioner, Lordship.
You are appearing on behalf of?
S. Bodo, Lord.
On request made on behalf of S. Bodo and the counsel for the petitioner. When?
Lordship, any day, Lordship, kindly adjourn for the day only, Lord.
Or list after 1 week.
Lordship, deeply obliged.
Lordship, I beg to mention item number 30, Lord. Thank you, Lordship. Actually, in this case, the respondent number 4 has filed affidavit today.
Hmm.
So 10 days may be granted for filing
Item,
40.
your 40,
Petitioner,
your good name?
yes, Allah.
On request made by Salam, then a counsel for petition. List after 2 weeks.
Yes, Lordship, in the first week of March,
Yeah, after 2 weeks.
date may be given.
Hmm?
Date may be given like
13th March.
May I please, Your Lordship? I beg to mention item number 24 and 23 and 24, my lord. Under item number 24 and 25, my lord.
24 and 25.
25, my lord.
Yes.
My lord, I have to file a rejoinder affidavit, my lord. My lord, 2 weeks I may be granted to file a rejoinder affidavit, my lord. Both is cases.
Your good name?
L. Borua.
On request made by L. Barwal, then a counsel for the petitioner. List after 2 weeks.
That's 24 and 25, my lord.
May I please, Lordship.
Hmm.
With consent of the other side, Lordship, I beg to mention item number 46, Lordship. Respondent has filed their affidavit on yesterday, Lordship. So 2 weeks time may be allowed to file affidavit in reply, Lord.
46.
Yes, Lordship.
Your good name?
MS Mondal.
On request made by MS Mondal, list the matter after 2 weeks.
May I please, Your Lordship, I beg to mention for the item number 15, Lordship, kindly pass over the matter for the day and may take in the item for next week.
Year 4?
For Mr. Z. Bathok.
On request made on behalf of G. Bathak, learned counsel for the petitioner. List after 1 week.
May I please, Lordship, item number 10, Lordship, it is meant to be, instruction is awaited, Lordship. So 2 weeks time.
Wait, that one you wait for your turn.
Lordship, item number 11, Lordship. Kindly allow me to withdraw this petition, Lordship. With liberty to file it afresh.
Mr. A.D. Chowdhury, learned counsel for the petitioner, prays for withdrawal of this writ petition with liberty to file afresh. Who appears on the other side? Mr. Learned advocate appears for respond number 7. And Mr. P. Nayak, learned standing counsel, appears for the PWT. Stop. Writ petition is dismissed on withdrawal
With
with
liberty.
liberty as paid.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention a matter relating to promotion, Lordship. Lordship, matter may be listed for order for taking steps by paper notification, Lordship.
When do you want?
26 February.
No. 1st March.
March of
May I please, Your Lordship? I beg to mention, my lord, item number 60. It's a hearing matter. Maybe, my lord, it is a time may not permit, my lord. Then Lordship may kindly fix the matter on 5th of March. I am for the petitioner, Lord.
Can request made by Mr. S.
S. Chowdhury.
Chowdhury, learned counsel for petitioner. List on 5th March.
Deeply.
I am the respondent number 7, Lordship. I have prepared to Lordship with written submission.
How about 3, 4, and 5 R Deca?
My lord, I am appearing, my lord. I am also coming.
You are ready?
Yes, yes.
Okay, submit. Parties have submitted the written arguments. Hearing concluded, judgment reserved.
Deeply obliged. Item 2, 3, and 4.
Heavily George. I am for the petitioners in item number 3 and 4. We have already filed our argument
When?
in filing session.
No, you are supposed to file here. Submit here.
On the last day when it was listed, on the very day we have filed here. Madam.
How about you?
I written a
You have for 3 and 4.
3 and 4.
You have another copy.
I don't possess today. I will provide if required.
Then you will fix a date. How about you? You are appearing for?
I am for item 2, my lord.
Mm.
I am relying on their affidavit. Your
argument.
Okay, on request made by Mr.
UN Chetri.
UN Chetri, learned counsel for the petitioner in WBC 526 of 2022. List on how, when do you want?
In March. In first week of March.
Okay.
maybe on 7th or 11th, 8th.
7 will be difficult. We'll have it on 4th or you want it on 11th?
8th or 9th, my lord.
8th or 9th is a holiday.
Okay, then 11th.
Is it okay? You
Yeah,
submit,
okay.
you, no, not now. You submit on 11th.
Highly up.
Okay.
Item 5, 6, and 7.
But if I am ready with the written arguments, sir, from the last 3 occasions, the standing council have taken, they have thought time.
Yes.
to-
We are prepared the draft. Today I am submitting, Lordship.
Huh?
Today I am submitting the written argument on behalf of respondent number 1, 2, 3, and 4.
1, 2, 3, and
Three and
4.
four.
Who are those?
Health Department, Lordship.
How about Barbujari?
Yes, my lord, for private respondent number 5, my lord, in WPC 5231, my lord, I am submitting my written argument.
And you are the standing council health.
No, my lord.
I am appearing on behalf of
He
Health
is for
Department.
the
Lordship.
health department, but he is also submitting his written argument.
Okay.
Lordship, I may be allowed to point out some subsequent development, Lordship, in the writ petition. Lordship, during the pendency of the writ petition, the next higher post of associate professor was due, Lord. And they have promoted the respondent number 5 to the next higher post of associate professor during the pendency of this writ petition, Lord, without informing this honorable court. So this may be also for, because we have made a prayer in the writ petition.
Have you incorporated that in your argument?
Lordship, this was subsequently we have come to.
Incorporate that in your written argument so that this court can take some.
I have the copy of the order of the subsequent order of promotion, Lord. Of the respondent number 5, Lord. They have promoted, the case was for the as a promotion to the higher post of assistant professor. What happened?
You are promoted now.
But I will have to take instruction.
Because I have the copy, Lord.
I don't have that instruction. But
Then you take instructions and come back.
instruction,
We'll list on 11th.
Yes.
Okay.
and otherwise.
On
also, my
request
lord,
made by R. Babujari, learned counsel for the respond number 5 in WBC number 5231 of 2022.
my lord,
List on 11th March.
apply.
That day you bring. In the meantime, you can incorporate that.
Incorporate in that.
But otherwise also that is not the subject matter of the present date petition.
So
And
their
it will be
prayer
in
was
due course of-
made, Lordship,
it
in
will
the
be in due course of action, my lord.
Okay.
Anyway,
Item 8 for motion. The last occasion, my lord, your lordship was asked for on delay, my lord, delay part.
Hmm.
My lord, the process is still going on, my lord. Petitioner received a letter on 10th of February, my lord. This is the copy, my lord.
No, process may be going on.
My lord,
But why are you filing the contempt so late?
my lord, the order passed in 2019, my lord.
That's why 2019 order. Have you explained that in your contempt petition?
Yes, my lord.
Where have you explained?
My lord, paragraph number 3, my lord.
Just
And-
nothing?
And 5, my lord.
There's nothing on your delay in filing the contempt. You file an affidavit explaining the delay.
Obliged.
Mr. K. Kalita,
Yes, ma'am.
learned, no. Heard Mr. K. Kalita, learned counsel for the petitioner. The petitioner shall file an additional affidavit explaining the delay in approaching this court. In explaining the delay in filing the present contempt petition. Otherwise, no contempt lies. You have to file a fresh petition.
My lord, I will file a additional affidavit.
List after.
Next week, my lord, on Wednesday. Obliged.
Item 10.
Lordship, 2 weeks time may be granted to take instruction, Lordship. I have not received any instruction.
What was this matter about?
Lordship, the petitioner is a candidate of Staff Selection Commission for Armed Forces. Lordship, he scored higher marks than the other candidate in ST category.
But R. Sharma, learned counsel for the petition. On request made by Ms. R. Devi, learned CCC, 2 weeks further time is allowed to enable her to receive instructions. You on that?
Yes, Lord.
List on. 15th March.
Obliged.
Item 12.
May I please, Your Lordship? The instruction is still awaited, my lord. We made the communication, but it's.
All this is, you just have to get the status of the appeal filed by the petitioner.
My lord. We have made the communication to department. My lord. Little accommodation is given, my lord. I will bring the.
Heard MS SP Chowdhury, learned counsel for the petitioner. Mr.
J.K. Parajuli.
J.K.
Parajuli.
Parachuli, learned government advocate, is allowed another
10 days, my lord.
another 2 weeks time to receive instructions. List after 2 weeks.
13.
May it please, Your Lord. Actually, in this case, Lordship, Annexer 8, Lordship, order dated 9/8/2023 is under salient, Lord. Page 55, Lord.
Yes.
Your Lordship, a departmental inquiry has been conducted, Lordship. And after submission of inquiry report, this final report has been served to the petitioner, Lordship. And he was
After this inquiry report, any order has been passed.
This is the final order, Lordship. Annexer 8, page 55, Lordship. After the inquiry report.
So you agree with this compulsory retirement?
Lordship.
Otherwise, you've been given a superannuation awards, benefits.
Lordship.
It would not be a impediment for you for future employment.
Lordship.
Okay, heard, Mr.
R. Fukan, Lord.
R. Fukan, and the counsel for the petitioner. Issue notice. You agree?
Yes. Okay.
Central Bank.
Yes.
On behalf of all respondents,
Yes.
MS,
S. Yasmin, on behalf of M. Sharma.
S.
Yasmin.
Yasmin Leonard's counsel appearing on behalf of R.
M. Sharma.
M. Sharma, Leonard Standing Counsel, Central Bank of India, appears on behalf of all the respondents. Accordingly, notice on respondents are complete. However, extra copies be furnished. List after 4 weeks.
Obliged.
14.
May it please, my lord. Matter pertains to not conducting of my department department promotion committee, my lord. It's been 20 years.
Conducting.
My lord.
Non-conducting of.
My lord, DPC, my lord, DPC. my lord. It's been more than 20 years that I am serving, my lord, in the said department. My post has been regularized also in 2005. Still, my lord. My lord would kindly have my representation at
Yes,
page
star.
18.
My lord, the thing is that regulation order is not here. That regulation that she is claiming that she has been regularized is not a part of this petition.
My lord would
Record
kindly
that.
have page 15, my lord. It is there, my lord. Page 15. If I may read, my lord, confirmed in service in the cadre of grade 4 with effect from 1/7/2005 against the post permanently retired by.
Where is that order?
My lord, next page, my lord. My lord, this much only I have, man.
My lord, that
This from the
we have to see, my lord, whether regulation was made to a personal post. If it is personal post, she cannot have promotion to the next level. That is the my lord law held by the division bench even. So that is what my lord we have to see whether that was regulation to the personal post. That part is not there. I have to seek, my lord will issue notice, I have to seek instruction from the department. Since the petitioner is not having the document. my lord.
Heard, Mr.
PR Sharma.
Learned Counsel for Petitioner. Issue notice.
All the respondents. my lord.
Mr. Adar, Leonard Edition, Senior Government Advocate. Appears on behalf of all the respondents. Accordingly, notice on respondents are complete, however, extra copies so and so. List after 4 weeks.
My lord, if it pleases my lord, a date may be.
List on, today is what, 21st?
Second.
Problem is there are holidays.
My lord.
Okay, 1st April.
Highly of it.
17.
May I please your lordship, matter pertains to regulation of service of the petitioner in terms of letter dated 5/12/2003.
Page.
Page 19, annex of 4.
Page.
19. Annex of 4.
Page 19, is there a type copy?
Type copy is page 14, lordship. His name is in serial number 98.
Serial number?
98.
Yes.
Though his matters has, though service of the petitioner both regular establishment against the section post, but regular payment will not be paid to him.
Regular pay is not paid to you.
Lordship.
Your GPF account also is open.
Lordship. Annex 3. Page number 17.
So what is your prayer?
Regular.
Yes, who appears? PhD. Standing Counsel PhD.
Yes, I will inform them, my lord. Though I am in there, but I have no knowledge of this matter. my lord.
Okay, Hurt MS.
D. Datta.
D. Datta, Learned Counsel for the petition.
Court number 2.
Mr.
P. Das, my lord.
P. Das, Learned Standing Counsel. PhD shall receive instructions in the matter. List after 2 weeks.
2 weeks, my lord. Oh,
Okay,
18.
It's matter of correction of date of birth in passport.
In?
Passport.
Passport.
So it is erroneously 9/7/1984, but actual date is 3/10/84. Passport is page 11. Lord. Page 11, date of birth is 9/7/1984.
Then?
Also, Lordship, in another document, date of birth is 3/10/1984. Also, other card also same. PAN card is also same. Due to this erroneous entry, Lordship, it is very difficult for the petitioner to move And
Gogoi,
So Lordship may kindly peruse the passport Lordship, page 11 Lordship.
I'm on that.
Page 11, my lord may kindly peruse date of issue Lordship, 18/10/20 Lordship. Date of expiry Lordship, 17/10/20 Lordship. It's a not valid document as on today Lordship.
18/10/2010.
18/10/2020.
So your passport has expired.
Lordship, long back.
During that, Lordship, if I renew in that time, then previous record is come, not their correct.
Long back,
They said
Lordship. Now
without-
online system is there Lordship.
Now,
When
see, on
they
an,
said, Lordship,
on
without
an expired passport,
expired.
what order do you want?
Lordship,
And what we can do Lordship?
question is that, Lordship, if we get an order from court, they can renew it with correct. date
You
of
want a
birth.
renewal of your passport through the
Lordship,
court,
Lordship.
through the court.
No, no. Date of birth is, it is wrong.
Date of birth is wrong. Okay, we assume your date of birth is wrong. If your passport was valid,
Right.
I could have asked Gogoi to do something.
Lordship.
Your passport expired in the year 2020.
20.
Now is for you.
I have filed representation, Lordship.
Have you renewed this?
No,
passport?
no, no Lordship.
Renew, Lordship, I want to repeat. Renewal is just in online already upload all document. Just renewal, everything is come, not it is corrected. Then I go up again and again to correct this question. Without judicial order, we cannot.
First of all, Lordship, you have to place the honorable court the renewal passport Lordship. After that Lordship, now Lordship in the record Lordship, it is not the renewal passport Lordship. It's
When
like-
there is no passport,
Lordship,
today,
then-
today there is no passport.
Lordship, today's Lordship, nothing is there.
There's nothing. What can you do?
Still,
Then I'm dismissing this with petition.
Lordship, kindly one judgment is also there, Lordship.
What judgment?
In this judgment also 13 years after expire Lordship, it is also renewed. But court has give direction to correct.
Renewal part Lordship, you have to apply online Lordship. Now it's a process of online process, you have to apply Lordship. And after renewal Lordship, he can come for correction also.
This
Lordship.
is a different facts and
Lordship.
circumstances. These are different.
Also, our High Court judgment is also sorry annexed Lordship.
This judgment is not applicable at all Lordship. Here our High Court judgment is here Lordship. In expired document Lordship, how it can be Lordship?
You first renew your passport. After that, you apply
Lordship.
for correction of date of birth. If nothing happens, then you can approach this court. Otherwise, this is nothing.
Lordship, our High Court judgment is there.
What High Court judgment?
Page 19 Lordship.
Page
19 Lordship. According to representation, it is may be corrected Lordship.
here the passport was valid.
No, Lordship. Passport was from 2010 Lordship. After 10 years, order is from 22 Lordship.
He must have
10 years
renewed
it
it.
is
He
also
must have
valid,
renewed
Lordship.
it. There's no mention here that
After
the
12
passport has expired. There's no mention here. Is there mention in this court
It is also
order?
expired passport, I think.
It is nothing is there in the record.
Nothing is there.
Even Lordship 2010 to 2020. This Lordship.
First, you
sleeping ideally,
renew,
Lord.
you renew
Lordship.
your, maybe now you'll have to apply afresh.
They-
Isn't
erroneous-
it?
Lordship.
Now the question of renewal does not
Lordship.
arise.
Lord.
You'll have to apply fresh.
Lordship.
So when you are making your
Again, Lordship, at present, Lordship, the The external affairs ministry's guideline is
annual
that
it is
lordship,
also
after
defective,
expiry of
lordship.
two
After
years, lordship, it will lordship go lord. And all the files are lordship, expiry files are after 2 years lordship.
We doesn't understand what it is lordship.
And so lordship, first
After
year
correction, after renewal this, they will not get it. I go again and again in first time lordship. From 2010, I am trying, still not. They say after in the time of renewal, we can correct it. But in the time of renewal, they said no. It is already uploaded. We cannot say after judicial, without judicial order, we cannot do this. So I undone. That's why I couldn't.
correction part lordship at any time after issuance of the document. If there is any wrong entry lordship, correction can be done at any time lordship. But it should be a valid document lordship. It is not a fact that lordship, there is a guideline of the external affairs ministry lordship. If any wrong is there lordship, he can apply to online lordship. But here the document is not a valid document lordship.
Your passport is not valid. It expires in 2020.
I
Now
tried,
it's
lordship. After
2024.
trying, lordship, I come this court.
Why are you wasting this court's time? I'm going to dismiss with cost.
No, lordship.
মানে রিনিউয়াল কাগজপত্রবিলাক তো দেখো দিয়া নাই না ইয়াত এখন নহয় না এটা আমি কোর্ট অর্ডার তুলে কি আছে
What order do you want on an invalid document?
আপনি রিনিউ করা ডকুমেন্ট করবেন না
You renew your passport or file, get a fresh passport. Now even the renewal period is over, I think. You
Then
withdraw.
he can today also lordship in the online portal. He can today also lordship assist. Today also lordship.
Computer does not comply.
Yes, because this is a
What do you
invalid
want?
document lordship.
Withdraw this petition.
Say Chalamgir and the counsel for petitioner press for withdrawal of petition mistake.
The time representing
Gogol
all the respondents.
DGC appears on behalf of all the respondents. The petition is dismissed
Invited to file. If not collected, I will invite to file again.
with liberty to file affairs. The petition is dismissed on withdrawal with liberty as per.
Published.
19.
May I please allow?
Yes, please.
Lordship, this matter pertains to appointment of Gram Pradhan, your lordship. And lordship, accordingly, I have been selected, your lordship, for the said concerned post of Gram Pradhan for the concerned village, your lordship.
Okay.
And the selection is,
Where's the select list?
yes, at page number 22, lordship, annex 3.
Yeah.
At page number 22, lordship, annex 3, lordship. My name is there at serial number 13, your lordship.
13.
13, your lordship.
Chatial.
Salim Ali, your lordship.
Salim Ali.
Sati Ali, your lordship. Salim Ali has been selected, your lordship, at 11 March 2023, your lordship. But your lordship, till date, 10 months has been elapsed, your lordship. No appointment order has been issued. But similarly situated person from the same selection list has been appointed, your lordship. That appointment order is at page number, your lordship, 45. It is a typing copy, your lordship, annex 9, page number 45, your lordship. It is from the same selection list, your lordship, the person has been appointed. The similarly situated person who was selected from the same selection list, your lordship, had been appointed.
All
your
these
lordship.
persons.
All these persons, your
1
lordship.
to 7, 1 to 15.
Yes, so 1 to 15, lordship, has been appointed, your lordship, from the same selection list, your lordship.
Let us see. Rajan Bora.
Yes. It is Rajan Bora, the serial number 1 from lordship. Again, Bipin Kumar Nath is lordship.
Serial number
From
5.
5, yes, lordship. Then Bhaskar Bara, your lordship, is 8, serial number, your lordship.
Yes, Chitia.
Yes, my lord, instruction, at least a notice may issue, my lord, because the petitioner there.
There's no point of issuing.
No,
notice.
there may be some
I'll
appeal-
give you time to take
No,
instruction.
there may be some appeal may be pending against the petitioner also, some other person may apply.
That's why I'll give you time to take instruction.
With the interim
Yes.
prayer, lordship, I have an interim prayer, your lordship, to keep alive the selection list and direction may be issued to the respondent authority, Your Lordship, to restrain to give new advertisement, issue new advertisement. Your Lordship.
expired, my lord. It is not as past the one.
I'll give him 2 weeks' time. Let him
Lordship.
come with instructions. We'll see.
No new advertisement may be issued, Lordship.
Lord MS
G. Bora, Lordship.
G. Bora, Leonard Counsel for the petitioner. Mr. T.C. Chutia,
I am for 2, 3, 4,
is
5, and 6.
additional government advocate,
One.
additional senior government advocate shall take instructions as to why the petitioner has not been appointed as Gaon Pradhan of Sikoni
Borhula, Lordship.
Borhula, despite being selected by way of the selection list dated
11 March, Your Lordship. 23.
11th March 2023. Stop list on when?
2 weeks, my lord.
11th March.
Yes, 11 March, Monday.
File
Okay.
your prescription.
20. My pleasure, Lordship. My lord, this case relates to the compassionate appointment, my lord. Initially, I have filed a writ petition, my lord. My case was not considered. Thereafter, my lord, the Honorable Single Judge has disposed of the writ petition. Thereafter, my lord, that did not comply, it subjected a contempt petition. There, my lord, contempt petition, we came to know our name has been selected by district level committee, my lord. Now, ball is in the court of state level committee. Only my limited grievance is that, my lord, the matter has to be taken a call by the state level committee.
Where the district level committee?
That before coming to that, I like to draw Lordship's attention, my lord. Why I have come now, my lord. Lordship will see the page 63 is the operative part, my lord.
Yes.
And district level committee, my lord, from that contempt case, my lord, we came to know that, my lord, page 58, that name has been recommended to the state level committee by the DLC. Page 58, my lord, bottom, my lord.
Page 58.
58. What now? Extreme bottom, my lord.
Saurav Atul Saikia.
My lord. And the recommendation part, Lordship will see the page 59, my lord. The case, may I read, my lord, page 59. The case of the series of the Saikia recommended on the ground that he has a period of 1 year and so food and civil supplies silcher and sent to the district level committee for consideration by the director by letter number so subject to the availability of the vacancy for a period of so supply and so. Sri Atul Saikia, the case was considered sympathetically as the applicant had applied in the due time on the food and civil supply and same was sent to the district level committee and director food and civil supply appears the applicant had lost the strength as per the Honorable High Court so and directed to forward the same the state level committee for consideration.
Not consideration. If
Right.
the same can be considered.
Yes, lost strength.
State level committee, let them consider.
Yes, my lord, let them come and call, my lord. What is that?
I will obtain instructor whether it is placed before the SLC or not. What is the result of it?
That also will do, my lord. May come up on.
Dispose of directing SLC to consider, if not already considered.
Yes, yes, and whatever outcome is to be communicated.
If considered, then outcome to be communicated.
Yes, that will do, my lord. That will do.
Lordship, direct them to consider if it is in the June of Pilot Expert scheme. As per scheme.
As per law, my lord.
Yeah, Barwell, counsel for the petition.
Scheme call a belag scheme or try to na.
You are for respondent?
I am for respondent, my lord.
All can.
All the respondent.
All, my lord.
Mr. T.C. Chutia, and additional senior government advocate appears on behalf of all the respondents. All respondents,
all.
including
All state, my lord.
yes, civil supplies.
Civil supply. All, my lord, comes under state.
Stop. Para. The petitioner's father, late Atul Saikia, while working as superintendent of food and civil supplies under the establishment of diet in harness on 5/1/2006. Stop. When did you apply?
My lord, within the right period of time. my lord.
The petitioner thereafter applied
Page
for,
28 be seen if required.
applied for page
26, my lord, or 28, my lord. 28.
for appointment on compassionate ground within the prescribed time. Stop. However, if the case of the petitioner was not considered by the concerned district level committee, he approached this court by way of filing WBC number 8084 of 2022,
One.
which was disposed of by order dated 16/12/2022, page
Page 44.
directing
Operative part.
the
46.
Deputy Commissioner Pacha, Silcha to place the claim of the petitioner for compensation appointment before the next available DLC of Kachar district, and the same be considered as per law. Stop. Para. However, as no steps were taken, petitioner had to file, where's the contempt?
Page 62.
File contempt case number 502/2023. Stop. During pendency of the said contempt petition, the district level committee considered the case of the petitioner, and accordingly, the contempt case number 502/2023 was closed by 13/12 by order dated 13/12/2023. Stop. The DLC district level committee in its meeting held on 7/4/2015.
My lord.
Is it?
Yes, it's continuation from page 48.
No, but then
7/4/15.
contempt was disposed in 2023.
My lord, that time they have informed the court. They filed an affidavit in the court, then only we came.
Okay, then I wanted to say contempt case number 502/2023. No? After that, you can sign. During the pendency of the contempt petition,
They filed the affidavit.
the respondents filed affidavit stating that the DLC had considered the case of the petitioner on 7/4/2015.
In the minute of.
Accordingly, by order dated 13/12/2023, the contempt petition was closed. Stop. Para. The grievance of the petitioner before this court is that the state level committee is yet to consider the case of the petition. Stop. Para. Considering the limited prayer involved, district petition is disposed of. Directing the state level committee to consider the case of the petitioner.
If not considered.
The case of in its next immediate sitting, if not already considered. If the case of the petitioner has been considered, the outcome of such consideration shall be communicated to the petitioner forthwith. with the above observations and.
And next available SLC, my lord, late, not
No,
later than 3 months, my lord, sometime we
I
keep.
can't give a time.
Yes,
It will be next available.
my lord, only that will do, my lord. I may be permitted to serve a copy along with the copy of the writ petition.
Petitioner is permitted to serve a copy of this order to the.
Along with my lord.
To whom? Chief Secretary?
My lord.
To the Chief Secretary, Governor of Assam, along with the copy of the present writ petition.
Lodge. Oblet. Petition stands disposed of.
21.
My lord. My lord, here all the petitioners are casual workers, master role workers, my lord. My lord, may kindly turn to page number 7, my lord, paragraph 4, my lord.
Yes.
Yes, my lord, I am going through page paragraph 4, that the petitioner begged to state that as directed, the respondent number 5 submitted the pre-Assam fiscal responsibilities budget management 1 AFRBM list and post-Assam fiscal responsibilities budget management AFRBM of master role fixed pay casual worker of Panchayat and Rural Development Department of Dhubri district. But unfortunately, the name of the petitioners were not listed in the AFRBM list. The aforesaid list was submitted before the respondent number 4. Thereafter, the respondent number 4, by circular dated 1/3/2019, directed the Chief Executive Officer of all districts, including the respondent number 5, to forward the list of district-wise casual
So you want
workers.
your name included
Yes, my lord. My lord, the
and
circular is.
minimum scale pay.
Yes, my lord.
Yeah.
My lord, this matter may be disposed of in light of a similar order. They have annexed at page 43. Be disposed of today.
My lord, page number 43. My lord, this was not disposed of, my lord. We have withdrawn this case earlier because. No, that was the thing, that there was some typographical mistake, that's why, my lord. My lord, may kindly issue notice and let them whether my name can be adjusted, my lord, because my lord, I'm taking my lord to annexure number.
The direction which is
He's
given.
giving you a way out.
My lord,
You-
I'm taking my lord to annexure number 2, my lord.
Third MS
SD Chaudhary, my lord.
ST Chowdhury. Your name is not here?
My lord, my name is not here, but I'm here. I'm on behalf of T. Diwan, my lord. He is not able to present, my lord, so he told me to present.
Have you
And
signed the Vakalatnama?
yes, I will file this wakalatnama today only. I will.
My lord, that page, paragraph 9, the direction to the authorities is very clear. I mean, it will only help her case. Can dispose it of today itself, para 9, my lord, which is at page 44. Similar order. Bail her out also.
Yes.
Yes, my lord, if that being so, my lord, if permit me, I can give my name so that they can verify my name, and if I am eligible, may grant that minimum wages to me.
You've been serving us. You are serving us casual workers.
Yes, my lord, casual workers, master role workers. My lord, may kindly page 14, my lord, annexure 1, my lord.
1 minute. Third MS.
S.T. Chaudhary, my lord.
S.T. Chaudhary, learned counsel for the petitioner. Also heard Mr.
P. Handy.
P. Andy, learned counsel appearing on behalf of A. Conwar.
K. Kunwar, my lord.
A. Conwar, learned
Senior standing counsel, PN.
senior standing counsel, PNRD, for the respondents.
1, 3, 4, and 5.
1, 3, 4, and 5, and Mr. P. Nayak, learned standing
R2.
counsel, finance, for respondent number 2. Stop. The petitioners are working as tax collector oblique road moharer oblique office peon on casual basis in different town panchayats under the office of the chief executive of, no, you're under respondent number 5,
Yes, my lord.
CEO, Dhubri Zilla Parishad.
under the office of the chief executive officer, Dhubri Jilla Parishad. Stop. Grievance of the petitioners before this court is that their names are not included,
Yes, my lord.
are not included in the pre-Assam fiscal, what is it? Pre-Assam,
The Assam Fiscal Responsibilities Budget Management.
where is that stated?
Para 4, page 7.
In the pre-Assam fiscal responsibilities budget management list, correct?
Yes, my lord.
Stop. By way of the present petition, petitioners are praying for inclusion of the names in the pre-Assam fiscal responsibilities budget management and also for minimum scale of pay. Stop. Mr. P. Hendrik, learned counsel appearing on behalf of Mr. K. Conwar, learned senior counsel, learned senior standing counsel PNRD submits that if the petitioners make individual representations, then the respondents would consider the matter.
Along with their appointment order.
Along with the appointment order, the respondents would consider the matter within a specific period of time. Stop. Para. Recording the submission made by the learned by Mr. P. N. Learned counsel appearing on behalf of Mr. K. Conwar, learned senior standing counsel, PNR. This petition is disposed by directing the petitioners to make their individual representations, enacting their appointment orders within a period of
My lord, prior to 1/9/2005.
when are we
Within a period of 3 months.
My lord, 2 weeks.
within a period of 2 weeks from today. Stop. To whom is the representation supposed to be addressed?
Finance.
Finance.
As per this order,
To the head of the department of it, then they will forward it to the finance department. There is a committee there. Committee will
Make reference to the concerned authorities, sir. Stop. Draft. The concerned authority shall examine the representation, the individual representations made by the petition and take a decision as to whether the petitioners can be included in the free Assam fiscal responsibilities budget management within bracket AFRBM list prepared by the department on when was it made? On 1/1/2020, on 1/1/2020. So the entire exercise, should be carried out and completed within a period of 1 month.
3 months, my lord, will take some time,
Within a
verification,
period of 3
independent
months.
verification.
From the date of receipt of the representatives from the petitioners. Stop with the above observation and direction with petitioner.
Last.
22.
May please, your lordship. This is second time of litigation, my lord. What happened, my lord? Earlier, this petitioner has approached this court by filing a writ petition, and that case has been disposed of by giving an observation. Lordship will find that observation at page 29, my lord. Page 29, my lord. In the middle of that page, my lord, 10, paragraph 10. His number is 10. As regard any of the petitioner who may not have the satisfied the requirement to having the work continuously for 10 years, we
You are
request.
reading from where?
Yes, lordship.
Reading from page.
Page 29, lordship.
Para?
Para, my lord, that is 10. This is number 10. In italics, my lord.
There's no para number here.
10, lordship, not para. That is in the earlier base, the writ petition, the third line. 9, 10. There is a 2 number. This is quoted page, my lord. As per para 10, as regard any of the petitioners who may not have the satisfied the requirement having worked continuously 10 years, we request the respondent APDCL to also consider their case and find out a suitable economic package for them as per the acceptability of the respondent APDCL ordered accordingly. On the basis of that observation, my lord, my case has been disposed of, my lord. And in that case, my lord, my name was at serial number 15 as a petitioner, my lord. Thereafter, what happened, my lord, we approached the authority concerned. The authority, as per the minutes, lordship will turn to page 31, annex 4. As per that minutes, it was resolved by the authority concerned that some portion of money has been given to the employee who were casually working under the APDCL, and the rate has been fixed. In the bottom, my lord, that page, my lord, page 31. For fixed outsource unskilled, 16,000 per month. For fixed outsource semi-skilled, 18,000. For fixed outsource skilled, 20,000. But subsequently, what happened, my lord, that resolution has been cancelled, my lord. And in my case, my lord, what order has been passed? In this regard, lordship, the authority has passed a speaking order. Lordship will find that speaking order at page 35, annex 7. Turn to the next page, my lord, 36, the operative portion. In that page, my lord, second paragraph, as regard placing the petitioners into the other category for giving them a suitable economic packages, if they have not completed 10 years of services, that the details have been collected, and it appears that if as of now, person seeking identical pair amounts to 806 individuals, and the total financial involvement in the event of enhancement of the wages to those persons, including the present petitioners, would amount to approximately rupees 21 crore 80 lakhs 87,200 per annum. The present status of the APDCL is not is such that the company would not be able to bear such huge financial burden. And accordingly, my lord, my payer was rejected. And later on, what happened, my lord, they have decided to re-verification of the petitioner, my lord. And accordingly, my lord, when turn to page 40, my lord, they have re-verified, and the APDCL authority, respondent number 3 and 4, has verified our documents and send it to the department. And I have everything, my lord. Annexure 9, my lord. Existing as per database 300 and page 40, annexure 9.
There's no annexure 9.
Page 40.
That is
39.
annexure 9 is page 39.
39, lordship.
Yeah.
39, sorry.
Yes.
And as per this, my lord, they have sent a list about their existing
outsourced employee, my lord. My name in the list is at serial number 131, my lord. I have given the relevant portion type copy, my lord. Along with the original one, my lord, there's a huge volume. In my name is at serial number 131. Thereafter, what happened, my lord? One order has been passed by the judicial authority again asked for a list who were working in the department for enhancement of their remuneration, my lord. And in that list, my lord, that is my impugn, my lord. One provisional list has been prepared by the respondent number 3, my lord. In that list, my lord, my name has not been considered and my name has not been sent to this authority. Now my pair is there, is that, my lord, since I have working as per the list prepared by the department, as per my as Annex 9, my lord. My name was there, but in the final provisional list, my lord, there my name has not been reflected, and I have not been considered. That means, my lord, at this stage, my lord, my pair is that, my lord, my name may be sent to the authority for the finalization.
That will have to
take instruction.
see what
In fact,
instructions.
the order that is being impugned, if your lordship will have that order at page 58. It starts at page 58. This is the list of employees who are considered for enhancement of pay. The last portion at page number 63 of that order, your lordship. The first terms and conditions. If there is any objection regarding inclusion or deletion of any name in the above list, petition is to be forwarded to the office of the CGM, HRA, APDCL through proper channel with all supporting documents such as payment records, age proof, education qualification certificates, etc. The same will be considered by the committee configured by office order number so and so, dated 14/12/2020. All he has to do is avail this opportunity, your lord. He has not done that.
My lord, what happened, my lord? When I have approached the authority, my lord, they have said that the time is over, my lord.
Obviously, you must have approached late.
Then, my lord, this opportunity may be given to me, my lord. We will approach the authority, my lord.
Let him do it within a week's time. We'll consider.
Yes, within a week, my lord, we will approach the authority by giving our representation, my lord.
How many petitioners are here?
Only one.
Heard Mr.
D. Bodo.
P. Bodo and a concept for the petitioner. Also heard Mr.
KP Pathak.
KP Pathak,
For all the
consulting counsel, APDs. For all the responses. Stop. The petitioner is aggrieved by the office order dated 14/12/2023. Inasmuch as his name has not been included in the list in the list of the outsourced workers under Johar Electrical Circle APDCL who are getting direct payment from APDCL with regard to enhancement of his remuneration. Stop. I will just say that no need to go into all these details. Stop. In the said order, in the said office order, dated 14/12/2023, the terms and conditions number 1 within bracket, terms and conditions number within bracket Roman 1, small, provides that if there's any objection regarding inclusion or deletion of any name in this above in the list, petition is to be forwarded to the office of the CGM within bracket HRA, ABCCL through proper channel with all supporting documents, which will be examined by the committee constituted by office order dated 14/12/2023. Stop. Para. Accordingly, dispute petition is disposed of, directing the petitioner to file his petition before the CGM, isn't it?
CGM, sir.
The office of the CGM. Office of the CGM. I do not know if he is a member of the committee.
Okay, directed to file his appeal to file his petition expressing his grievances in the office of the CGM within bracket HRA, comma, ABDCL within a period of 1 week from today. Stop. Drafted the concerned authorities shall.
10 days,
consider-
10 days, my lord,
Why do you want 10 days?
to file a petition, my lord.
Why not you take it within 1 week? Okay, within a period of 10 days from today. Stop. Drafted the concerned authority shall consider the application made by the petitioner and dispose of the same in accordance with law within a period of 1 month.
Very well.
1 month from the date of receipt of the application. Stop. With the appropriate observations and directions, inspect petition is disposed of.
Oblige, your lord.
Obliged. 23.
May I please? This matter relates to compassionate appointment. The petitioner father was working as section assistant, Your Lordship, in the Department of Irrigation, died on 17/11/2010, Your Lord.
2010.
Your Lord. Thereafter, the mother of the petitioner, Your Lordship, filed an application on 6, submitted an application, Your Lordship, and but the same was not considered, Your Lordship.
When did your mother apply?
It was she was applied on date not mentioned, Your Lordship, but Your Lordship kindly peruse the letter dated 14 June 2013, Your Lord. Page 20. The Executive Engineer, Your Lordship, by issuing this letter, informed the mother of the petitioner that her application was rejected, Your Lordship, on 9/12/2011, Your Lordship, in the DLC petition. But without furnishing any grounds, and the minors also has not been, and the decision also not been communicated to her, Your Lordship. Thereafter, Your Lordship, petitioner on attaining majority, Your Lordship, submitted an application, Your Lordship, on 27/6/2023, Your Lordship. Page 23. Page 23, Your Lordship. This is the letter, Your Lordship, submitted by the petitioner, Your Lordship, received by the Deputy Commissioner, Your Lordship, along with the annexure, Your Lordship, furnishing the details, Your Lordship. But till date, Your Lordship, his case has not been placed before the DLC. So my simple prayer, Your Lordship, is application may be placed before the next DLC meeting, Your Lordship.
There are two aspects here. What do you say?
His case, Your Lordship, is covered by the Supreme Court judgment, Your Lordship, and Solution, but the state of Bihar, Your Lordship, and passed by this honorable court, Your Lordship, which I have annexed in page 27, Your Lordship. Similar facts, Your Lordship, this honorable court has directed to place the case of the petitioner in that petition, Your Lordship, before the DLC, citing the judgment passed by the honorable Supreme Court, Your Lordship. Paragraph 2, Your Lordship, page 28, may kindly put, Your Lordship, of that case. Similar fact.
Yes.
My lord, but the present view of the honorable court is different, my lord. Very recently, the judgment is passed by this court, my lord.
And when his mother's case was rejected on the ground of overage, Your Lordship, and I have annexed the other card, Your Lordship, kindly peruse page 21, Your Lordship. When her case was rejected, Your Lordship, he was 38 years of age, Your Lordship. So on that ground, it could not have been rejected, Your Lordship.
Para 24 is relevant, my lord.
Para
24, exactly similar to this present case, my lord. And one more judgment is there, my lord. This is also December month.
There is no reservation for the minors. This is also decided by this recent.
But
Yes.
Honorable Supreme Court, Your Lordship, in
Discussion on this, all the
2006 9 SSC, Your
everything
Lordship.
is discussed in this order. In the last page, my lord. In the last page.
Yes.
In that case, Your Lordship, I may be allowed to go through this order, Your Lordship. Lordship, kindly fix it next week, Your Lordship.
Okay. On request made by Mr. K. Mira,
Camera, Your Lordship.
General Counsel for Petitioner. List on.
Next week, Your Lordship.
After 1 week.
1 week. Obliged.
Item 62 from supplementary list.
May I please have the lordship? My lord, the matter relates to, my lord, regularization of services of these 11 petitioners, my lord. My lord, our services has been extracted by the, my lord, the NIT Silchar from last 30 years as a, my lord, master rule workers, my lord. Just for a moment, my lord, I beg to draw my lordship's attention to an order, my lord. Is at page 25. Annexure 3 to my petition, my lord. As per the recommendation of the 14th meeting of the Finance Committee under item number so and subsequent approval of the BOG in its 27 meeting of so, the following daily wage workers are hereby placed into the next higher wage as mentioned against their names. My lord, all these petitioners are name are also been reflected in this order. They have, my lord, a little bit of kind, my lord, that our wages has been upgraded, my lord, and it has not been disputed. And last order of such upgradation, my lord, may be pleased to find is at page 29, my lord. So this, my lord, various order reflects that our continuous service till date, my lord. Now, my lord, for the purpose of regularization of our services, my lord, we did approach before my lordships, my lord, by way of a writ petition, my lord, in the year 2007. And my lord, I will straight away, I beg to draw my lordship's attention to the operative part of the order is at page, my lord, 39. Therefore, in view, my lord, may I read over the operative part, my lord? Therefore, in view of the above position, no direction can be issued at this stage to the authority of NIT to regularize the services of the petitioners. However, taking into consideration the length of their services, as some of them are continuously in service since 1980, 82, 1985, etc., it is directed that whenever the ratio of 1:1:5 between the faculty and non-faculty members achieved, petitioner's case shall be considered, taking their respective length of services into consideration. The authority shall also consider
the case of the petitioners belonging to the SC/ST while filling up the backlog vacancies pursuant to the communication dated 1st of June 2006. With the above direction, the writ petition is disposed of. Now, my lord, this order had again been assailed before the division bench of this honorable court, my lord, and the operative part is at page 43, my lord. The appellants were recruited as the master rule workers in the National Institute of Technology, Silchar, grade 3 and grade 4 post. They claim to have served more than 30 years. As per the so-and-so, the Board of Governor, so-and-so, the master rule workers will be regularized in accordance with the provisions of law. Since they were not regularized in terms of the resolution, they made a representation and thereafter approached this court. The stand of the respondent is that their appointments were beyond the sanction post and they could not be regularized. Learned single judge on due consideration held that no direction could be issued to regularize the services of the appellant. However, it was directed that on reaching the requisite ratio of non-academic staff to academic staff as per norms, their cases may be considered taking into account the length of their services. Aggrieved by the above order, the appellants have preferred this appeal. We have heard learned counsel for the parties. Learned counsel for the appellant submits that those who had already served up to 30 years may be taken to have worked against the sanction post. In any case, posts may be sanctioned retrospectively so that the benefit can be given to them under the welfare laws. The appellants are still admittedly continuing in service. Thus, according to the appellants, their cases was not at par with the master rule employees who may have served for short duration. Having served for the role of life, they could not be told that there was no post against which they could work. Having regard to the above facts, the appellants have already served for more than 30 years and they are still continuing in services. It will be in the interest of justice that the issue is considered again by the National Institute of Technology, Silchar, as well as by the Ministry of Human Resources, Government of India, as far as possible within 6 months from the date of receipt of the certified copy of this order. Pending decision on the issue, the appellants may be allowed to continue in service. If the appellants are aggrieved by the decision which may be taken, they will be at liberty to take their remedies in accordance with law. The appeal is disposed of. Now, my lord, the division bench is very clear, my lord, that the NIT Silchar is required to take a decision in respect of our regularization, and till a decision is arrived, we should be allowed to continue. My lord, in fact, we are now being allowed to continue. Now, what has happened, my lord? Thereafter, a resolution has been adopted. My lord may be pleased to find at page 50, my lord. This is a minutes of the meeting held on 1st of June 2013 at 11:30 am in the meeting hall of the NIT Transit House. Now, straight away, my lordship may kindly come to the last paragraph, my lord, to consider the judgment of Guwahati High Court in writ appeal filed by so-and-so, so-and-so and others, India and others. So this is the, my lord, manner in which they are dealing with, but till date, my lord, as per the various record which we have received, till date, my lord, they have not taken any decision. And on the other hand, my lord, they are continuing with the recruitment process for filling up the post where we can be accommodated or regularized. That, my lord, advertisement and recruitment process is still going on. And in another case, my lord, which has been listed today as item number 43, my lord, in that writ petition, my lord, we have prayed for certiorari of the, my lord, the fresh recruitment drive which they have initiated. And in this petition, my lord, we have prayed for a mandamus from my lordship, my lord, that our case should be considered for, my lord, regularization in terms of the recent development, my lord, which has been taken place, my lord. This is my limited prayer in this petition, my lord.
My learned friend has referred to the judgment of the Honorable Court in the decision with page number 43. Pursuant to that judgment, there were several advertisements were published by the NIT, and accordingly, this petitioner, even in this particular present stage, when this particular advertisement has been issued, they have been allowed to participate in the selection process because this is not automatic law. The regulation, because at that point of time, when they had joined this particular institute, there was no sanction post, because this is the communication we have made, repeated communication with the Ministry of Higher Education with regard to their regularization. But the communication that we have received is that since that was not a sanction post, and in that view of the matter, this regulation cannot be automatic. Now, fact is that these persons who are overage, even they are not having that adequate qualification, they've been allowed to participate in the selection process. If they participate in the selection process, compete in an open competition, and accordingly, if they're qualified, they will be obviously they will be absorbed, and regular their service will be regularized. It's not a case that they will come and on the basis on the strength of their continuity service. And we are not saying that they will be terminated from the service, that their service will be discontinued.
Okay. you
This is
file
not
your-
our case.
File your affidavit.
Yes, everything will be clarified in our.
We have the concept of petition. Issue notice. Mr. SP Chowdhury. The not standing council, no.
Yes.
Union of India,
My lord, A. Gogoi is sometime appears.
have you served copy?
Copy this one?
Yeah.
Yes, my lord.
Mr. Yogi Goswami, the not CG Singh.
Please.
Appears for respondent number 1. And Mr. SP Chowdhury, the not standing council, NIT.
Yes.
Appears
2, 3, 4.
for the respondents
2, 3,
2,
4.
3, and 4. Notice and respondents are complete, however, extra copies. Respondents are allowed to file affidavit.
Yes.
List after 4 weeks.
Obliged, Lord.
You furnish extra copies?
Yes.
See.
Item
Our
31.
services may not be disturbed in the meantime, my lord.
That
No, we
yes,
are not disturbing.
Mild.
yes, sir.
Mild.
They're continuing in the service for last 3 years.
Obliged, my lord.
31 for admission.
Yeah, please, Your Lordship. Lordship, the matter relates to regulation of service.
PHE finance.
PHC has not filed any affidavit in spite of giving, Lordship. A reply filed, Lordship. Yesterday we have filed our reply.
Our affidavit we have already filed, Lord.
Filed,
She has
Lord.
filed a
How
report.
about PHE? Who's the PHE respond number?
It's, technically, it's, I'm not going to. And also this matter is duly covered by Your Lordship's order, Lordship, at page 35. It's 35. Only date of appointment is different topic. In 1988, both the petitioners were appointed as workers Alasi Lordship. Thereafter, they were deputed in the Assam Urban Water Sewage Board, where they were promoted to the regular post Lordship.
Where's PHE?
Lordship, it may be taken up on Tuesday with affidavit in reply, Lordship.
You
Yes.
file your reply.
Yes, Lordship. Yesterday we have filed a reply.
MSR David and the counsel for the petitioner submits that she has filed a reply to the affidavit in opposition filed by the respond number 2. When? On
Tuesday, Lordship, there is some urgency.
registry to verify and place the same on record. List the matter again on. Let it be on witness day.
Lordship.
28.
Or Lordship, Thursday, Wednesday, there is. Thursday, Lordship.
Are you on our hearing day?
Yes. Lordship, yes. Wednesday,
Witness day is 28.
Lordship. Obliged, Lordship.
32.
My lord, I have been appointed as a lower division assistant in Milo SHC under Director of Vessel.
Up to date, instruction is not yet received, Lordship. Only 2 time it will give it.
My
We'll
lord,
file a affidavit, Lord.
my lord, this matter is pending since 2022 and My salary is stopped, my lord. Although I have been working, a salary has not been received due to want of police verification.
What do you want?
After 2 weeks time, if you go, Lord, I will find my application.
You have received instructions?
No, Lord, up to the instruction is not yet received.
You are applying for?
From respondent number 4, Lord. Joint director.
Okay, heard, Mr.
I strong hand.
HR Chaudhary.
HR Chaudhary, learned counsel for the petition. Mr.
RS wrong.
RS?
Wrong hand.
Wrong hand. Then the standing counsel.
Yes.
Kaglianglo.
Correct.
Who to respond number 4? He's allowed 2 weeks time to file affidavit.
Earlier, one affidavit was filed, my lord.
This
By,
after 2 weeks. Yeah.
a date may be fixed, my lord.
13th March.
33.
May I please, Lord. Before Lordship, my lord, there is a sub-inspector of police, my lord. And while he was holding the office, my lord, a so-called notice was issued to him under 65 of the police manual, my lord, and as well as under section 7 of the Rule 7 of the Assam Disciplinary Rules, my lord. And for being unauthorized absence, my lord. Now, what has happened in the inquiry? He participated in inquiry, so-called notice was given. He gave his reply, my lord. Finally, my lord, inquiry report was forwarded, my lord. While forwarding the inquiry report, my lord, the disciplinary authority, my lord, already has come to a finding, my lord, that a major punishment should be imposed, my lord. That is not permissible because it amounts to a second, it is of second so-called notice. That your lordship may.
1 minute. Are all parties represented?
Participated. He participated, my lord. Because that your lordship will find.
No, all parties are there.
All parties of the state of Assam is there, my lord. The government, my lord.
You also for the police?
Yes, ma'am. Because after 42nd amendment, my lord.
So you are representing all respondents?
All respondents.
We have
filed affidavit, my lord.
Yes. You ready?
Yes, sir. After 42nd amendment of the constitution, my lord, the second suppose is not required, my lord. Now, what has happened in this case, my lord, your lordship may kindly come directly to come to page 57, my next 10, my lord.
Page?
Page 57 of the petition, my.
Yes.
Your lordship, you are hereby informed, inquiry into the charges framed against you in connection with department proceeding has been drawn numbers against you to complete it. A copy of the inquiry report is enclosed herewith. On perusal of the inquiry report, I find the charges of gross misconduct, indisciplined conduct, and dereliction duty. You are given 15 days time to make representation, if any, above referred inquiry. Further, you are asked to submit written 15 days time where you wish to for a personal hearing before the final order on this matter by the disciplinary court. That was passed on 17/3, my lord. Thereafter, my lord, I submitted. Then another so-called notice was issued, my lord, that your lordship kindly pays 58, my lord. That is by another authority, Assistant Inspector General of Police Administration, my lord. Next page, my lord. You reference to above, we are hereby submit your response as to why major punishment should not be inflicted upon you, being absent from duty so long, committing a gross misconduct, dereliction duty which is proved in a department inquiry. Your reply must reach 7 days for further necessary action. Accordingly, I submitted my reply, my lord, and I ordered it, your lord will find, on 30th of November, my lord. The Assistant Inspector General of Police, my lord, who became the disciplinary authority, passed an order whereby I was dismissed from service, my lord. Now, the point before that in fact, our High Court, my lord.
1 minute. Where's the order?
Order of dismissal, my lord, you also will find at page. It starts from page 64, my lord. 64 and 65, my lord. Operative part 65, my lord. As proved sufficiently in department proceeding, the witnesses, I, as a disciplinary, dismissed him from service. I preferred an appeal, my lord, before the Inspector General of Police, and that was also dismissed by order dated 7 February 2020, page 66, my lord.
You're challenging your order of dismissal.
Dismissal. Basically, my ground is that, my lord. Because because there's a decision of our High Court, my lord, Justice Mehdi, my lord, also is similarly situated Plaza 3.
No, it's not a question of following one judgment every time. You have to place your fact.
Yes, I'm coming to mind. What is said, but in this case, your lordship, right? Disciplinary authority already has come to a finding that I should be dismissed for authority. He has already made up his mind, man.
No.
Because already he has made up his mind that he has proposed to a major penalty, man. That is not permissible, my lord. At least he could, at best, he should have forwarded the inquiry report, my lord. Forwarded the inquiry report, my lord, to file any representatives, if any, my lord.
You've been given a copy of the inquiry report or not?
Yes, I'm given that. But before that, he already has, by issuing a second so-called notice, my lord, he has already come to a finding that I have committed an offense, and a major penalty should be imposed upon him. He has perused the inquiry report, and already that is not permissible, man. That is my case, my lord.
You're not challenging the inquiry proceedings.
No, because if that goes, my lord, it will go back, my lord. Because they were totally prejudiced, my lord. They already made up his mind to impose penalty, my lord.
If anything goes, it will go only up to the show cause notice.
Yes, after show cause notice.
But the inquiry report will still
Yes, because they already predetermined themselves to impose a major penalty. That is not permissible, my lord. At best, they should have forwarded under Rule 9A, my lord. Of the disciplinary report, they are supposed to forward it, my lord. But they don't have to come to a finding that I have committed an offense or major penalty should be imposed, man. Because they have perused the inquiry report, man. Already predetermined themselves that they will impose penalty, man. That is not permissible, man. And in fact, our Union of India Muhammad Rabjan case, my lord, 1991 Supreme Court, my lord. There also that has been discussed, my lord. Initial case also there has been discussed. That I have been in that judgment, my lord. That you also may kindly find, my lord.
Where the judgment?
But that. Yeah, there you also better fix it.
You bring copies.
Yes, I will file as judgment.
Come prepared.
Oh.
On request made by Mr.
He got to give, my lord.
It's after 2 weeks.
Because in ECIL case, my lord, that constitution may have held, my lord, that inquiry report only has to be furnished. They cannot come to a finding, my lord. That is not permissible.
34 and 35.
Maybe your lordship. Lordship, in item number 34, I am appearing for respondent 224 and 17. I'm making this prayer on behalf of Mr. P.K. Tiwari. Matter may be adjourned today.
Lordship, if I may, Lordship, please the facts, your Lordship. Lordship, in item number 33 is a matter of 34 is a matter of 2022, your Lordship, where we have challenged the allotment of marks by the DPC. And item number 35 is a matter we have where again we have challenged the constitution of a DPC of the year 2023. So Lordship will be pleased to detach the matter because Lordship, in item number 34, the pleadings are complete and the matter can be taken up for final disposal maybe in next week, your Lordship. So Lordship may be pleased to detach these matters. They can file their affidavit in item number 35, your Lordship. 34 may be taken up separately.
It can be detected. Only prayer is that he has sought for 3 weeks time.
In item number 35, they can take 3 weeks time.
No, 34 also he has sought.
But 34, Lordship, because the next DPC is again in April, your Lordship. So the matter, if I may pay, the matter may come up on 7th, your Lordship, 7th of March, your Lordship. And pleadings are complete, 7th of March.
March there will be some difficulty.
Lordship, maybe on 5th, your Lordship, 5th of March.
Not 30. We can have it on 12th.
Let it be on 12th.
12th of March, your Lordship.
Okay. On request made by Mr. N. Gowda,
Lord.
Learned Counsel for the petitioner, list this matter on its own on 11th of March.
11th of March, 12th of March. Only thing, Lordship, the two matters will be 12th of March. The matters will be detagged, your Lordship.
I said on its own.
Lord.
Stop. Okay, then you said on request made, deduct this matter from WBC number 1530/2023 and list the matter on its own on 12th March 2023. So in the other case, 1530, you heard Mr. G. Gautam, learned counsel for the petitioner, N. Gautam. So on request made on behalf of Mr. B.K. Dewari, learned counsel, appearing for the respondents, 2, 3, 4, and
No, in 35, it is 2, 3, 4, 5, and 10.
2, 3, 4, 5, and 10. How much?
3 weeks time.
List the matter up to 3 weeks.
Lordship, if I may, Lordship add final disposal, Lordship, in item number 34, your Lord. For final disposal,
Okay,
your
on top,
Lordship.
item 34, on 12th March, for final disposal.
Lordship.
Deeply obliged.
36.
Lordship, before the other party starts, and before the Lordship also starts, Lordship, I have a prayer because the main counsel conducting this case, Counsel Bigo, is on legs in court number 1. He's currently assisting the Advocate General of SAP. Lordship, may I pray that it might be taken up tomorrow or any other hearing date, Lordship, if possible, so that it's easier for the conduction of this case.
Friday, Lord. Monday next.
Friday is not a hearing day.
Hearing day would be
It's a
best.
admission
Lord.
matter, Lord. Then, Lordship, Tuesday next.
Okay, heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for petitioner, on request made on behalf of Mr. B. Google and the standing counsel, Health Department.
Health Department, Lord.
List on.
What's the Lord?
Highly obliged.
37.
May I please, your lordship? My lord, a very short issue, my lord, is that we are the petitioners, my lords, are working as a tracer in the, my lord, Department of Irrigation. My lord. Now, in the irrigation department, my lord, as per my knowledge is concerned, my lord, no recruitment service rule has yet been framed. But even then, my lord, those employees are working in the different cadre at par with the other engineering department had been promoted. Exactly here in the same case, my lord, those persons, my lord, who are working as a sub-engineer grade 2 had been recently promoted to sub-engineer grade 1. Now, my lord, we are claiming our promotion from the tracer to the post of sub-engineer grade 2. Now, my lord, there are vacancies which is already there, wherein, my lord, we can be considered for our promotion. As, my lord, in the other department, also in the water resources department or other the equivalent department in the state of Assam, such tracers has already been, my lord, promoted. So now, my lord, to that effect, my lord, we have also filed an affidavit also, my lord.
I have some instructions, but let me after 2 weeks, Lordship, Lordship may dispose of after 2 weeks.
2 weeks in the
Because,
meantime, my
Lordship,
lord.
I am told, Lordship, the draft rule has been framed for the promotion of the tracers, Lordship.
Are you following the draft rules?
Lordship, and the draft rule has been sent to the finance department for their concurrence. They have to make some queries, Lordship. It is stated.
My lord, with all respect to my friend's submission, my lord, preparing a draft rule and coming to its attaining finality, my lord, by passing in the assembly and then the assent of the governor, it will take a long time, my lord. So, my lord, may I pray, my lord, till this case is considered that this post of the sub-engineer grade 2, my lord, can be kept in hold, my lord, till the our
No,
case.
no.
Then, my lord, if they filled up by direct recruitment,
Lordship,
then we will be, my lord, deprived of, my lord.
I'll have the country instruction. Let it be.
Okay.
Then after 10 days, my lord, maybe.
After 10 days.
Mr. Abayan, learned counsel for the petitioner, on request made by N. Obadia, learned standing counsel. Irrigation department, list the matter again on. You want after 2 weeks?
2 weeks, Lord.
My lord.
13th March.
My lord.
38.
Obliged, my lord.
But in this matter, we have received instruction, my lord, we will file affidavit.
In this matter, my lord, I appeared on behalf of a private response number 6, my lord. So we came to know about this petition, my lord. We filed our affidavit. Local account, my lord. They did not serve the copy, my lord. They did not even take the step also, my lord.
We have already taken step.
Let them serve a copy to
1 minute.
Yes, I will serve the copy. In the meantime, the respondent authority have filed an affidavit.
How do you say they've not taken steps? Have you checked the records?
Hello, AD card has not received back. Hello, I have not received the.
If they have not taken steps, will AD card come back?
I have not received the pilot notice back.
Then how do you know that this case is pending here?
From the office, my lord, they informed me that one case has been filed and then.
Which office?
By my department, my
Third MS?
A. Vijayapura, my lord.
A. Bajaburam, then I counsel for the petitioner. So, Mr. T.C. Chudiyal, then additional senior governor. Submits that he has received instructions and prays for how much time?
2 weeks time.
2 weeks time to file affidavit.
My lord,
Mr.
Shiladitol.
date,
Shiladitol.
date may be fixed. my
1
lord.
minute.
Shiladitol. My name is reflected.
Oh,
Wait.
Sheila, Leonard Council enters appearance on behalf of respond number 6 and also prays for 2 weeks time to file affidavit.
Can it be
Right.
posted on 13th of March, my lord?
List down. Yeah, 15th March.
Must.
Notice, copy.
39.
You finish a copy. Finish an extra copy, dude.
Yes, sir.
May I please?
Yes.
I am for a respondent, Malak.
Oh.
Affidavit has already been filed and they
Mm.
submitted their reply. Meetings is almost completed.
Reply file.
My lord, I have filed reply.
Mm.
So in this case, my lord,
Then we list it for hearing.
that
Huh?
can, yes,
Pleadings-
Admission.
Briefings are complete.
yes. The date may be,
Who is the appealing for union?
No, I am appealing for it.
Your union. Oh, you are paying for all the respondents. Okay, Leonard Counsel for the parties submits that pleadings are complete. Accordingly, issue rule. As all parties are represented, no formal steps are required. List the matter for hearing in its usual course.
my lord, a date may be fixed. In this case, my lord, urgency is there.
List the matter for hearing on 19th March.
41.
May I please, your lordship, actually remember this case regarding appointment, selection and appointment of PW person on GC, my lord. My lord, after hearing.
Last occasion, Lordship was directed to obtain me instruction whether this person can be accommodated in the meantime or not. Because his certificate is valid up to a period, 2005, 2025. And certification is having temporary. My lord, I have received the instruction, but the instruction, my lord,
Why don't you file an affidavit so that he can?
I will, yes. My lord, 10 days time, I will file the affidavit along with some other related, my lord, grounds also there, my lord, I will place 10 days, my lord.
Okay.
Yes.
But Mr. C. Barrow, Leonard Counsel for the petitioner, Mr. B.K. Das.
My lord.
Leonard Standing Counsel for the respondents 1 to 4.
Dates and not been dated double like
Instructions and pray for two weeks time to file counter affidavit. List the matter after 2 weeks.
10 days, my lord, because this is already,
Yes.
if it is observed also, he'll get.
10 days, 2 weeks.
My lord. My lord, for respondent number 1 to 4.
Huh.
Yes.
May,
Obliging.
may I pay for date, my lord, is 4, 5, 6, any date, 4,
Let me quickly.
5, 6,
That will not be 2 weeks.
4, 5, 6,
13th March.
13 months may not be, my lord. Before that, because I'm out of station.
After
12,
your
11 or 12?
Okay, 11th March.
11 months, my lord, obliged.
42.
May it please your lordship.
Lordship, I am appearing on behalf of Mr. Aspiras for respondent number 4. My lord, I will take instruction.
Lordship, in this case, lordship, the petitioner was initially appointed as LD assistant in the Department of Director of Employment and Craftsmen Training, lordship. Lordship, in the year 1988, lordship. And he had now he is retired at the as of superannuation on 31/3/2022, lordship. Lordship, while he was initially
31/3?
2022, lordship.
Retired.
Yes, lordship. Lordship, while he was initially serving as LDA lordship, he was reappointed as on ad hoc basis as an LDA assistant lordship. And all of a sudden, lordship, he was released from his post on on 15/12/1989, Lordship, due to which he have filed a writ petition before this honorable court, and as per the direction of the honorable court, he was reinstated in the department on 1/12/1993, Lordship. The petitioner, Lordship, have filed this writ petition for Lordship for non-payment of salary and non-regularization of that said period, Lordship.
Third, Mr.
D. Burman, Lordship.
D.
Burman.
Barman, learned counsel for the petition. MS.
T. Bora.
G. Bora.
T. Bora.
G. Bora. Learned. You are appearing for
Behalf of SP Das.
learned counsel appearing on behalf of SP Das. Learned counsel for the respond number 4 is allowed. How much time?
2 weeks.
2 weeks time to file application.
Lordship, kindly fix the date, Lordship.
List on 15th March.
I'm open for running.
Highly obliged, Lordship.
Government executive respond no 1 2.
43 and 44.
In this case, Lordship, I filed my affidavit. Reading is otherwise complete. It can be taken up, if the Lordship just to take up today itself. It's a difficulty, I think, my.
My Lord, one of my senior colleague, MJ Bodo, had been admitted yesterday in a hospital, my Lord. So he has some difficulties today on, my Lord, anyway, one of the matter is fixed on 29th of this month. So on that day, my Lord, maybe please to take up.
MG Bora.
MJ Bodo is not well, my Lord.
But can he come on 29th?
No, Lordship, he's in hospital, TMC.
I know.
I
from
29, it could not come.
Then, my Lord, on second week of March, my
Lordship,
Lord.
there is some urgency in this matter. That's why on the last occasion, we have placed one miscellaneous application with
For
regard to
that, some agitation that has been withdrawn, my Lord. My instruction
Because
is it
the
has been
model code of conduct will come into play. So if the model code of conduct is come into play, they will not be in a position to give some sort of appointment because they are holding the stay order. The stay order, on the strength of stay order, also we are not in a position to proceed further. The issue is same, otherwise the two petitions have been filed with regard to same issue. My learned friend can cover up the entire.
There's one counsel in the hospital.
So that I can understand, Lordship, because I have talked to the learned counsel yesterday also. He said only for the day. He never told me about the 29th. Since the matter has been fixed on 29, considering the urgency, it can be fixed on 29. If he's having some difficulty, then it can be.
But he's saying that he won't be able to come.
How he knows that
he has some serious eye problem in his left eye. He has some blood clotting. And today morning he has put injection in his eye. Now he's in OT on GFC. It is GFC.
I have issue, Lordship, but the difficulty of the institute is also to be taken into consideration because if the model code of conduct comes into play, then the advertisement come from other part of the country.
So give a date.
Date of 29.
Okay, and request made on behalf of Mr. MG Barwa, learned counsel for the petition in WBC number 5406 of 2023. List on 29th. Okay.
Mal.
Obliged.
Obliged.
45.
May I please, so in this case, my lord, I am challenging that, my lord, I am fall under the category of physical handicap, my
I
lord.
have received my instruction yesterday. Lordship. I pray for 2 weeks time to file my affidavit.
You have received instruction.
Lordship, yesterday.
That may be fixed, my lord, because my lord already.
Yes,
my lord,
heard Mr.
D. Burwa.
Learned counsel for petitioner MS.
R. Bora, Lordship.
R.
For the
Bora.
Agriculture Department.
Learned standing counsel agriculture department submits that she has received instructions and prays for 2 weeks time to file affidavit. Prayer is allowed. List up to 2 weeks.
My lord, date may be fixed, my lord, if possible, my lord.
Okay, list on 18th March.
Obliged, your lord.
Obliged, Lordship.
47 and 48.
In this case, we have already prepared an affidavit, my lord. I have sent it for swearing, my lord. Let me, my lord, 2 weeks time to file this.
But I say cycle.
Just a minute. Coupon in a party.
More can I go? Official potato.
My lord, that the thing is this, that injury model may kindly continue. Order passed on 8/12/23. The on the last occasion, I have forgotten the last sentence of the order.
If you have forgotten, why are you remembering?
No, that kindly see, my lord, considering matter in its entirety, it is provided that the one post of the gate 4 to which the petitioner was selected pursuant to the advertisement that we kept vacant till the next reasonable date. On 19/1/24,
Heard R.C. Cycle and the counsel for the petitioner, Mr. T.C. Chutel and additional senior government advocate is allowed 2 weeks' time to file affidavit. List after 2 weeks, interim order pass earlier to continue till the next reasonable date.
obliged. The next case is also same.
Here also interim is there.
Yes, just a minute, my lord.
Item 49.
In this case also, Lordship, the recommendation, this item, that there is the interim order. Interim order is there. In the case, this
Interim order
second
passed
cases,
in both the writ petitions. Huh?
7326, Lordship. And last chance were given to them to file the affidavit. Because these are the selected candidates. Further examination is not nowhere here in the rule. Which has been provided certificates issued to these disabled persons by the competent authority. Again, the medical has no right to re-verify. That is why, Lordship, but that gate 3 posts are they are appointing, but gate 4 are neglected. That is why, my lord, the case may kindly be disposed of at an early date, because this gate, they have been issued not only by the district committee, by the government of India also.
Right.
Item 63 from supplementary list.
No. Item 49 is here.
Yes, my lord, we are for 49, my lord. Now, my lord, the petitioner's salary has been, my lord, stopped on the basis of, my lord, purported affair.
Bora, you have got instructions?
My lord, I'll take some more time to get the instructions. Peculiar case, my lord. He has an FIR, but he was appointed. Later, when he discovered that he has an FIR as well as charge sheet has been filed, but he is not named in a charge sheet. His name is Faidul Haq, and the charge in the FIR it is Faidul Sheikh. Whether this same, they are the same person, that is also a bit doubtful, my lord.
Now, once, my lord, my name is not, my lord, succeeded, and no cognizance has been taken against me.
FIR is prior to his appointment.
Heard Mr.
M.U. Mondal.
M.U. Mondal and the counsel for the petitioner, Mr. S. Bora, and the standing counsel BTC. Is allowed another
10 days, my lord. We'll get 10 days.
another 2 weeks' time to receive instructions.
But may Premature in current salary may be paid because there is no bar.
Let us see.
Lordship, fix a date, Lord.
I'll fix a date. List on 13th March.
On that day, my lord, interim period may kindly be considered.
13.
Obliged, Lord.
Item 63 from supplementary list.
Good, doctor.
This is the last proposal.
No, what proposal?
This is regarding arrear salary, Lordship. The wife of the deceased employee is before your Lordship. They have last occasion, Lordship, queries regarding.
It will take some time, my lord. Lordship, disposite of, my lord.
This is a proposal of July.
Yes, my lord.
Today we are in February
Yes,
2024.
my lord.
What is the latest position?
Position, my lord, the fund will be released, my lord, within, they will receive, my lord, in 3 months, my lord.
Have you got written instructions to that?
Yes, my lord.
Where is the written instruction?
No written instruction. My
Then?
lord. Verbal instruction I have received, my lord. Lordship, may
No,
disposite of, my lord, within, allowing us to.
After I dispose again, you will not pay. Petitioner will have to come back again. I know this.
Then, my lord, 1 week time maybe, and I'll take written instruction.
Okay, you get written instruction and come back. We'll fix it next week.
Yeah.
Okay, heard, Mr. You data?
Yeah.
Mr.
Zahid.
Zahid, Leonard counsel for the respondents 2 to 5. On request made by Mr. A. Jahid, let us counsel for respondents 2 to 5. List the matter again on 1st March.
Item 50 and 51 for orders.
What is this?
My lord, this review petition was, my lord, preferred against the order passed by your lordship.
Page?
Page, my lord, 84, my lord. Paragraph 3. In paragraph 3, your lordship held that the petitioner before lordship did not complete the required teaching experience of 10 years. Against that, my lord, the petitioner has preferred this review because
Is it a shortage of time? Yeah, what to do?
possibly fix the matter on the hearing day next week, my lord, so that it can be disposed of, my lord.
Yes, Deka?
Yes, Lord.
On request made by the parties. When do you want list of?
Next Thursday, my lord. 22. No, 29. 29. Vote is Sunday. 29, my lord. 29, my lord. God bless you.
Kindly my presence can be recorded, Your Lord.
MS
B does.
B does,
Second.
then the standing council secretary education appears for respond number 5. No, are you 5? No, then the standing council appears for the secondary education department.
Deeply obliged.
52.
BC na.
My business. Would you kindly adjourn for today, lordship?
Why?
Mr. B. Sinha left the court.
Otherwise, my lord, here case, my lord, he is a person, his brother in the my lord, Assam Rifles, my lord. So siblings cannot be, my lord, given opportunity of, my lord, his height is 2 inches less. So whenever court order was that, no opportunity was given. So if you want to them, give opportunity. Again, we have second time we have issued notice. He have given reply. We have not found any satisfactory reply, so order has been passed. So you are not entitled. That order has been challenged by a second petition. There also notice served. So what remains in the contempt, my lord? Nothing, my lord. Court's direction, my lord. Court direction in the contempt is in page 9 to 21. Page 19 to 21. 21 is the my lord, last paragraph is the direction. Not 21.
26.
20, yeah. Direction. Only to give notice. Notice was given, we have filed our affidavit. He has filed on reply. It was not found satisfactory. Ultimately, an order passed. That order again challenged by a second petition. Now, what remains, my lord?
Lordship, they have made contradictory statement, lordship. In earlier petition, they have
that
made
cannot
another
be
statement, and now
in
next petition,
contempt,
they
my
have made another statement, lordship. By this way, they have condemned the court, lordship. Lordship, fix another date, lordship. So kindly fix another date, lordship. BC will argue
This
that.
court
lordship.
directed them to issue notice.
Issue notice.
And thereafter pass orders.
Yes, we have issued notice.
So they issued notice, they pass orders, then.
Again, there was challengement by the second
Orders
petition.
challenge in another petition, isn't it?
Yes.
Yes,
Then
lordship. Lordship, in earlier petition, they have made another statement by filing an affidavit, lordship. And second petition, lordship, they have made contradictory statement, lordship.
So those contradictory statement will
Cannot
be
be
taken care in the writ petition.
Yes, in the
Not in
second.
the contempt. Contempt is just to see whether the order.
So kindly fix another, lordship.
I have no
Another, lordship. Mr. B. Sinha will argue, lordship.
I have no
Mr. B. Sinha. Okay, on request made on Mr. B. Sinha, Learned Counsel for Petitioner, when?
Lordship, next week, lordship.
List the matter after 1 week.
Item 54 to 59 for hearing. Well, these are very old matters, my lord. Lordship may kindly fix the matters on a hearing day so that my lord, this can be disposed of my. Today, my lord, perhaps time will not permit to hear this matter.
You are appearing for all the.
I am appearing in item number 57, my
Lord, I was appointed the amicus in all the cases, madam.
In 57, I am appearing for the petitioners.
57.
No, except one petition. In any case, one petitioner is except.
Oh, 57 you are appearing.
Yes, my lord.
Monda, Mahmood?
My lord, I am for one of the petitioners of WPC number 4431. That is petitioner number 5.
Okay. On request made by IS Cycle Council appearing for the petitioners in WBC 2194/2013. List the matter. When?
29th, my lord.
29, fix a lot of cases.
Along with the matter, my lord. It may.
Seventh, there will be some difficulty.
7.
2008 matter, my lord.
There will be some difficulties, 7.
29, my lord.
Okay, 29.
29, double edged.
Obliged, my lord.
Finish.
Obliged.